Happy New Year to everybody.
May I be permitted to mention one matter for extension of entry order? It was
Please mention extension of entry model. Please hand over.
extension of entry order.
Please write extension of entry model. Otherwise, people won't know for what it is.
Now the PMLA processing has now been quashed. The matter was last second in January when it was acted because of the state of the judicial actions challenging the PMLA procedure. It has been quashed.
No, but do I have determination for hearing matters? There is a change. 2019 to 2022.
Milord, may I have your lordship's kind leave to mention a hearing matter of 2019, Milord. This is regarding flying of hackney carriages.
Give it.
Your Lordship, may I be permitted to mention a matter? Your Lordship had heard two writ petitions on 23rd of December, and Your Lordship had directed to list the matters again today on 2nd January under the same heading, since my learned friend appearing for the respondent authority had sought time to seek instructions. But in the order, the date has been inadvertently mentioned as 21st instead of 2nd January, Your Lordship, in both the orders.
Milord.
And Your Lordship, one more matter I would like to mention, Lordship. We had filed it.
So let it appear on 21st. What is the
Lordship,
problem?
there's an urgency. The high demand is involved, and that is why we had mentioned earlier for upgradation of the matter.
So before 21st, what will happen? 21st is quite near. Don't worry. If something happens, you mention because things again. I'll have to bring it under to be mentioned. I don't know what the date was. Nobody remembers also.
Your Lordship, but one more matter I would like to mention, Your Lordship. We had filed a writ petition in the year 2024, and thereafter the matter appeared before Honorable Justice Rajabasu Chaudhary, and we had appeared virtually in the matter. And due to some technical glitches, the camera could not be turned on, and we had to seek an accommodation. And since then, the matter is running in the list, Your Lordship. And now we have received notice from the department for completion of assessment, and it was a challenge to 148 AD order. So, Your Lordship, they will complete the assessment, and it was a violation of natural justice, etc. So I pray for upgradation.
148 AD order. You had not got an interim order till now.
No, Your Lordship.
It will appear.
Milord, petitioner.
Yes, Your Lordship. It is at item number 400 and as mentioned.
You want upgradation?
Yes, Your Lordship.
You have to serve notice on the other side. Then.
Yes, I have already served, Your Lordship.
Let us see. Don't expect it to be upgraded immediately. We'll upgrade it accordingly.
Wait for Your Lordship.
Milord, petitioner's bank account has been attached. So kindly, this is not in the list, Milord. Kindly upgrade it and taking up the matter. I am praying for taking up the matter immediately because they have attached the bank account. Petitioner is unable to release wages and salary.
It is to the other side.
Yes, Milord. Yes, Milord.
Give it. Yes.
But I am praying for inclusion in this matter. This is a
Inclusion, please give.
Where my Ombudsman has already passed the award my challenging that insurance for fight particular litigation, I can interim order passed by the audited they have already deposited 50% of the award.
Very well, give it. Give it. Serve a notice on the other side. Whatever you are mentioning, please serve.
That the GST department is demanding the reversal of accuracy on the ground that the supplier has gone into liquidation. Your Lordship, this particular issue is now covered by the judgment of the Honorable Division Bench of our court, which is in the context of that. That once the supplier has gone into liquidation, the tax liability there.
Very well, give it.
Your Lordship, these are hearing matters, Your Lordship.
Hearing matters, you'll have to wait. Hearing matters, I'll not upgrade immediately. Let some motions be finished. Give it for correction.
One matter will appear on 5th.
Fifth on that day you mention, I'll correct it. It will appear on for correction. যেটা ফিফথে আসবে সেটা আর দিতে হবে না, যেটা ফিফথে আসবে না সেটা দিয়ে দিবে। When is the other one directed to appear? That was 5th and 9th. You remind me on that day. I'll incorporate it. I'll correct it.
May I permit?
Disposed of matter, it is difficult. 21st December, why you did not mention on 23rd, 24th? দেখেন দিদি ফাইলটা আনবেন দেখে নেন. Yes.
May I permit to mention one matter? The petitioner bank account is currency. The amount is also recovered.
দিয়ে দিন. You mentioned the grounds of
Yes.
urgency.
Yes.
How many matters are you mentioning?
No. 3 matters. Interim order. Interim order also you given the sleeve also. Interim order expired on 31st.
Extension of interim order and কিছু আছে দেখে নিন. Yes.
My lord, may I be allowed to mention for motion inclusion in the list? The matter was lying in the bench of Honorable Justice Rajabasu Chaudhary and has just come
Inclusion,
to this
please give.
and my lord, there are 3 matters that are of different financial years, but the same cost title is same, parties are same. So could those 3 matters be tagged?
No tagging business.
tag.
You please
Okay,
give,
ma'am.
it will appear. Yes.
Grateful, my lord.
Yes, madam.
My lord, both the, I have 2 matters to mention and both the matters are not appearing in the daily cost list. One is.
Please give it. They will appear.
Grateful, madam.
Thank you. চলুন লিস্ট কল করুন. দেখি একটু দিন. NYA টা কি আছে? NYA কি লেখা আছে নিচে? ফরম্যাটের নিচে NYA লেখা আছে. মানেটা কি? না না, তা তো হবে না. NYA টা কি? লিখুন. সেম অর্ডার করে দিন. সেম অর্ডার. নেক্সট. সেম অর্ডার. দিদি এর সঙ্গে ক্যান আছে অনেকগুলো. সেম অর্ডার. Next. Same order. Same order. Same order. Same order. না দাঁড়ান 32 এর নাম্বার চেঞ্জ হচ্ছে কেন দেখুন কি দিয়েছেন ঠিক করে দিন দেখে দেবে 32 সেম অর্ডার ওটা কি জিনিস ভাই জিজ্ঞেস করেছেন সেম অর্ডার থার্টি ফোর ইয়ে চেঞ্জ হচ্ছে দেখুন 33 আপনি কি দিলেন 34 কি দিলেন আপনি আমাকে দিয়েছেন কি দেখুন কি দিয়েছে 'সেম অর্ডার সেম অর্ডার সেম অর্ডার দুটো অর্ডার আছে হ্যাঁ 37 38 দুটোতে আলাদা আলাদা অর্ডার করবেন সেম অর্ডার করবেন দেখি থাক দিতে হবে না এখানেই লেখা আছে ওটা জেনে জানাবেন আমায় দেখি লিস্ট কল করুন পরেরটা
Your Lordship, I'm led by Mr. Animesh Paul. He couldn't come to the court today because of some personal difficulties. Kindly makes it not today.
देखिए एकটু কি মামলা লিখে দিন an accommodation is paid for on behalf of the petitioner. List this matter for further consideration.
Pass over.
Passed over. $26. देखिए পাস ওভার করে রাখুন সেকেন্ড কলে দেখি passed over. Pass over. Passing it over. Pass over. Passed over. Passed over again. Passed over. Passed over. $33 is different, $34 is different. Which one you are appearing? Next. Not passed over. You are ready? Very well. I'm passing it over in the second call. If they don't come, we can record. Next. Second call. Second call. Hand. Respondent. Next. What is this matter about?
File the application challenging that PPT there, so that no license we can take in my
License for?
license for digital cloud. But in fact, I not made the application at all.
You have not made the application.
Made the application at all.
Very good. देखिए
Page 20.
you are appearing for respondent number. Anyways, today is the first day they are not appearing. Liken in act order. None appears for the petitioner. Full stop.
My lord, I appear for the petition in this matter, my lord, 636 and 637, my lord. Similar matters, my lord, in respect of different contracts. Here, my lord, I am a weapons component manufacturer. I had, my lord, participated in a tender bid, my lord, submitted my bids.
File ta din.
I have been disqualified and then blacklisted, my lord. So what happens is, my lord, this is a monopoly industry. Weapons components I cannot supply to anybody other than the state. So if I am blacklisted, my lord, my business comes to a grinding halt. I am blacklisted, my lord, as far back as 2024. My lord, petition has been filed long back. We have not, my lord, been able to have it heard. Show cause was issued, my lord, on the 21st of November 2024. Thereafter, my lord, order banning me 9th December 2024. And your lordship is aware of the, my lord, conditions in tenders, my lord, promulgated by other procurement authorities of the Ministry of Defense also, which says that, my lord, prerequisite eligibility criteria is that if you are disqualified by any other state authority, my lord, you cannot participate.
You were given a hearing for before being
No personal hearing, my lord.
before being
No.
blacklisted.
No, I was not.
The show cause pertain to the
Show cause is
blacklisting
issued.
itself.
Show
Yes.
cause is issued, my lord. They have elicited written response. I have given written response. No personal hearing is afforded, my lord. The Supreme Court, in the decision, my lord, SBI versus Rajesh Agarwal, which was, my lord, passed in the context of, my lord, fraud declaration. They have said, my lord, blacklisting without personal hearing is honest. So, my lord, no personal hearing given. But here, what is more startling, I'll tell you, lord. What is the allegation on which I have been blacklisted? Allegation is, my lord, price collusion. The tender condition says if there is price collusion or collusive bidding, you are blacklisted. But if your lordship will see the show cause notice and the order which my lord blacklists me, they say that I and another bidder, my lord, bid from the same IP address. So we submitted our bids online. The IP address from which the bids are submitted, my lord, is the same. Merely on that basis, they say that no, this amounts to price collusion or, my lord, collusive bidding. You are blacklisted, disqualified and blacklisted. Now, my lord, what is startling here, I will show your lordship the chronology of events. What is the sine qua non to, my lord, determine whether there is price collusion or not? You have to open my price bid. There is a two-stage tender. Technical eligibility is first checked, technical bid is opened, and then, my lord, the price bid is opened. They have issued the show cause to me, and thereafter proceeded to, my lord, blacklist me before the price bid is even opened. My price bid has not been opened. So whether my price bid matches the price bid of this other entity.
Show me the show cause notice.
Yes.
Your response and their order.
Lordship.
Didi,
This is 3rd October 2024. If before that, my lord, may I invite your lordship kindly to page 369.
369.
369, my lord.
এখানে
Reason for technical evaluation.
just
Yes, my lord.
please give me a moment.
I'm sorry.
দিদি অর্ডার গুলো আলাদা করে রাখুন, সব একসঙ্গে রাখলে সব কিনে যাবে।
369.
Finish.
Page. Well, may I just show your lordship the chronology in which the tender has proceeded and how they have proceeded to
No,
my
let
lordship?
me tell me there. Let me see the order first.
Very well.
Then we shall.
Very well, my lord.
369.
369, my lord.
Yes.
So, my lord, after the technical bids were submitted, at page 369, lordship will find that there is an endorsement that is made. Reason for technical evaluation history. Then, my lord will find.
369 is letter for final payment.
My lord is looking at. My lord,
So this
WP
is-
4335.
Yes, 4335.
Yes, my lord.
Page 369.
P8, my lord. This is annexure P8.
It's annexure 37 of an internal annexure of some maybe some contract document or whatever.
Right.
But page
Mal-
369 is this.
My lord,
This is 369.
my lord,
দেখান ওনাকে দেখান।
I'm sorry, my lord.
This is page 369. এটা ওনাকে
Kindly allow me 1 minute, my lord. 4335 is item 43.
It's 636, the first one. 4335.
636. Sorry.
636.
This is item number 636. Which item number?
636.
Yes. Page number is not matching. How is that possible? Kindly allow me 1 moment, my lord. I apologize. Volume 3. How is it not matching?
Number no, this is 4340. They have written 360.
Yes. So is this item number 637?
This is 636. This
Yes.
one. They have written wrong WP number. It's 4340. He's checking the wrong petition.
So which petition should I? So give me this petition.
So, okay. First item number is 4335.
Yes.
Petition. But he is checking 4340.
So should I have?
Yeah.
My lord, if your lordship will kindly take the next item number. Facts are identical. I may invite your lordship to kindly take the other matter
We
first.
are at WPA 4335.
My lord,
4340. The 4335 is listed first, but the copy which your lordship is seeing is of that of 4340.
No, it's of 4335 only.
No, this is. but
Yes, this is volume 3 of 4335.
It doesn't match.
my lord, may I invite your
Maybe
lordship
your
to kindly,
numbering is wrong.
kindly, if your lordship will pass over and let me check this, my lord, resolve this difficulty. It's extremely urgent, my lord, but I don't understand.
Last 6 months, we are watching matter. They are not being taken up. Anyway, taken up. They may don't.
No, my lord, but I've been blacklisted since December
No, I'll hear
2024.
it. This can be resolved. Give me the other one. Next to the next two.
दूसरा फाइल निकालो यार मेरा मार्किंग नहीं है
इनका ही नंबर भी गलत है।
और दूसरा पिटिशन हमारे पास है कि नहीं
ये
हाँ तो इसका 4336 निकालो हाँ
438 আছে তো একটা নাকি?
अब उनको देखिए।
না কত? সরি 637.
637, if your lordship will kindly see, my lord, perhaps this will match. Page 369, if your lordship will kindly have, this is annexure P8.
দিদি এগুলো খুলে দেবেন না, সবসময় আমাকে ওইভাবেই দিয়ে দেন, কি অসুবিধা হবে? আমি বসে বসে 5 মিনিট আমার এইগুলোতে লাগে। কেটে দিয়েছি। এগুলো কি করে পড়বো আমি? এটা প্রত্যেকদিন হয়। বাংলা হওয়ার সময় আমি এইসব করতে বসি। It was 369.
Yes. Annexure P8, my lord, if it will match. Sir, আপনার match?
Yes, 369 is reason for technical
Lordship,
evaluation.
I think there's a miss.
So you correct your number.
My
Your
lord,
WP number is wrong.
I shall do that, my lord. I shall do that. No, sir, we have-
Because the WP number has swapped. This is
what we have
4340.
incorrectly marked. So this will be item number 636 in today's. That is a mistake we have made, perhaps. I apologize. My lord will kindly see here. Reason for
So we are
technical.
taking the second one first. Please number
Please,
it
my lord.
properly. That is 4340.
I'm
The
grateful, my
second
lord.
one is being taken up first. That is 4340.
Apologies for the
And
confusion.
which is the corresponding page of 369 in
I shall indicate, my lord. I'll hand up a note, my lord, indicating the corresponding page numbers.
Yes.
If your lordship will kindly take, my lord. Reason for technical evaluation. So after the technical bid is open, my lord, this is there on their online platform. Kindly see technical evaluation history. Thereafter, my lord, the date is 12th September, my lord, 2024, I think. Disqualified. Other details indicate in common. Kindly see the comments. The offer of the firm is rejected for quoting in collusion with the firm, Messrs. Naveen Tools Manufacturing Company. So they say, my lord, I have colluded with Naveen Tools in placing my bid. Thereafter, if your lordship will kindly take the next page, this is the first show cause notice issued to me on the 3rd of October, 2024.
Yes.
My lord will kindly see. Kindly allow me to finish, sir. Please kindly allow me to finish.
Yes.
If your lordship will see, my lord, this is to bring to your notice that an open tender inquiry vide GM such and such, dated 12th September 2020, was floated by Gun and Shell Factory for semi-machining of 81mm mortar bomb from rear part, forging, GSF drawing, etc. So this is the component that I am to manufacture. This is what the tender is for. After opening the GEM bid on scheduled tender opening date, it has come to our notice that two firms, Messrs. Ashoka Molders Private Limited, that is the petitioner company, my lord, and Messrs. Naveen Tools Manufacturing Company Private Limited, submitted bids from the same IP address. The above mentioned incident raises significant concern regarding possible cartel formation, which is a direct violation of competition laws and tendering regulations aimed at ensuring fair competition and transparency. Cartel formation is prohibited under the applicable competition and procurement laws. Both firms are expected to maintain the highest ethical standards and compete fairly without coordinating their bids. You are required to provide written explanation within 2 days from the date of this notice, clarifying the circumstances that led to both firms submitting bids from the same IP address. Failure to provide an adequate explanation or any confirmation of collusion between the two firms will result in severe penalties, including
But this is
disqualification.
addressed to some Ashoka Molders.
Yes, my lord.
And the writ petitioner is Neha Patodia.
Neha Patodia, my lord, is
Who is
director, my lord, of Ashoka Molders, my lord.
she? Ashoka Builders is not a party. Molders is
No,
not a party.
এটা কি করেছো তোমরা? How can that be? Yes, my lord. Petitioner number 2, my lord, is made.
Number 2.
Yes, my lord.
Very good.
So the officer of the company is made petitioner number 1.
Very good.
So when I was placing the first show cause notice, 3rd October 2024 at page 370.
Yes, I have seen it.
Also, my lord, kindly see who has issued this show cause notice. This is by the Junior Works Manager, GSF, for Executive Director. My lord, because there are regulations that are part of this contract also, which say who is the appropriate authority to issue the show cause notice and to take the decision. It has to be directly under the Ministry of Defense. So it is my submission, my lord, that these show cause notice and the order disqualifying me and, my lord, blacklisting me are not even by the
Order
competent
has also
authority.
been passed by the same person.
Same person, not competent authority under the extant regulation. I will show your lordship that. But more fundamentally, my lord, how can I be disqualified on a purported ground of collusion without the price bid being opened, merely because I have submitted the bid from the same IP address as another entity? My lord,
Yes.
this was responded to, my lord, on 22nd of October 2024. So because I did not respond within the specified time, that is 2 days, my lord, there's a reminder show cause notice that is given to me on 21st October 2024.
Yes.
Not trouble your lordship with that. My response is at 372. I've just sought more time, my lord, at 372. Thereafter, my lord will find at 373, again, show cause notice is issued to me on 21st November 2024. Again, my lord, allegation is the same. If your lordship will see the remarks on the right-hand side, my lord, the firms have quoted from the same IP address. My lord, firm names, Ashoka Molders and CNC Components, Naveen Tools. So they say, my lord, these Naveen Tools and I have quoted from the same. And my lord, this mentions two tender numbers, that those are the subject matters of the two writ petitions, my lord, 636 and 637 of your lordship's list. So, my lord, firms have quoted from the same IP address, remarks in the first one, and same one again, second one, my lord, both firms have quoted from the same address. That is the only allegation. Kindly see the next page, 374. In this context, in respect of GEM bid number such and such, GSF has issued show cause notice dated 18th October 2024, followed by reminder that is dated 21st October 2024 in connection with GEM bid number such and such dated 4th September 2024. Also, GSF has issued show cause notice dated such and such dated 3rd October 2024 following. In response, your firm had denied the allegations of partaking in cartel formation with any other competitive bidder. Further, you confirmed that your firm had no relation with Messrs. Naveen Tools and Messrs. CNC Components Private Limited. The case was put up to the competent authority with related documents. The competent authority has examined the facts and prima facie is convinced that the firm had resorted to collusive bidding. In response to the show cause notice issued by PV Ammunition Section, the firm had simply denied of indulging in such acts. However, it has not been explained on the commonality of the IP address with other participating firms. Therefore, the firm's response does not address the moot issue flagged by GSF. The firm has prima facie violated the basic principles of transparency, fairness, and competitiveness in the referred bidding by resorting to collusion with others. So, my lord, collusion is the ground, and my lord, the only allegation is same IP address. Then, my lord, paragraph 6, therefore, the competent authority has tentatively reached at a conclusion that the firm deserves imposition of penalty as deems fit. The above observations are tentative and decision of the competent authority are hereby forwarded to you for your perusal. Further, through this letter or email, you are being given an opportunity to explain your position stand in this matter and explain as to why any penalty as deemed fit should not be imposed. Your reply should come within 7 days. So, my lord, again, this is signed by the general manager for executive director, junior general manager, who they allege is the competent authority.
Joint general manager.
Yes. Joint general, yes, my lord. 376, again, reminder given to me, my lord. And then, my lord, again, my lord, my response is at page 378.
Yes.
Paragraph 3, my lord, at page 378, we have said, we never denied your allegation of same IP address of other bidders. We only try to convince you that that intentionally we have not made any cartel with any of the participating bidders of respective tenders at any regards, either in technical bid or in commercial bid. We still stand on our said fact. On detailed investigation of your allegation, it is found that due to network problem in the office of the following firms, they took support of network of our offices on urgent basis without sharing any detailed information to us. Names of the firms, CNC Components and Naveen Tools, my lord, with which I am alleged to have colluded, they are mentioned, and for which only the IP address has been found to be the same for all firms and not for any other terms of the tender. Moreover, as we had no previous knowledge about the above anomalies of IP address, therefore the same has been arise due to lack of knowledge. All precautions have been taken at our end not to repeat the same similar mistake in future. As mentioned, same violation of tender terms unknowingly caused by our side and may be considered by your kindness being one-time mistake without any bad intention. Considering the above points, you are requested to review your decision looking towards first-time unknowing mistake by our MSME firm, which is providing services to GSF since last 40 years and above. So, my lord, we admit that common IP address has been used. Same IP address, my lord, both firms have submitted. My lord, the registered offices are the same premises. Simplicity, my lord, they have gone ahead, use the same network. It's like my lord, for instance, if I'm doing a virtual hearing, I cannot, my lord, access network. I will ask my friend who's sitting next to me, please share. He may be the other side. Please share hotspot. So I can access, my lord, and log in and do the hearing. Is that collusion? That is the question that your lordship will have to consider, my lord. It is solely on that allegation that they have said I am colluding and they have proceeded to disqualify and blacklist me. Now, my lord, kindly see the impugned order. That is at page 380, my lord.
Yes.
9th December 2024. Subject is banning of business dealings. Regarding the two tender numbers, my lord, they are given. They are the subject matters of item numbers 636 and 637 of Lordship's list. Paragraph 1. This is to bring to your kind notice that your firm had participated in the above referred bids after opening of, kindly note, my lord, after opening of the technical bid. After opening of the technical bid, the following have been noticed. With regard to the first, my lord, this tender number, my lord, ending in 4335.
Where do I get that?
Kindly allow me one more, my lord. Oh, that is in the notice inviting, my lord, bids. I will show your lordship that. So, my lord, these are the two. The second one is, my lord, the tender that is in issue in this petition, my lord, where they allege only I have colluded with Naveen Tools.
Yes.
Allegation in both, my lord, remarks your lordship will find firms have quoted from the same IP address. Both firms have quoted from the same IP address. So, same issue in both writ petitions. Kindly see page 381 thereafter, my lord. Paragraph 380, last paragraph, my lord, they say show cause notices have been issued to me in respect of both tenders. Next page, paragraph 3. In response to the show cause notices, Messrs. CNC Components Private Limited and Naveen Tools had stated that there were network problems in their respective offices and therefore they took the help of the internet service in your office. Same has also been confirmed by your firm, VDE, letter number such and such, dated 29th November 2024. The evidence reveals that multiple bids were submitted from the same IP address, indicating a clear violation of the tendering process. By indulging in such acts, your firm have violated the basic principles of transparency, fairness, and competitiveness in the bidding. Therefore, the competent authority at GSF has reached a conclusion that your firm had resorted to collusive bidding with other bidders in multiple bids, which is nothing but resorting to adopting an unfair means to secure a contract during the process of bidding. Therefore, the competent authority, after duly examining the facts and keeping in view the gravity of the case, decided to impose penalty of banning of business dealings for a period of 5 years from the date of issue of this letter.
Very good.
This issue is with the approval of the competent
Show
authority.
me the contract now.
Yes, my lord. Kindly see again who has signed, my lord. Again, Junior Works Manager for Executive Director. Now, my lord, may I invite your lordship's kind attention to the contract. My lord,
Please take a seat. Take a seat. I'll call upon.
my lord, the relevant term of the contract is set out at paragraph 7 of the writ petition, my lord. That is at page 5. Clause 3.4.
Paragraph 7.
Yes, my lord.
The contract is not annexed.
Yes, it is, my lord. I'll show your lordship from there. Kindly take page 55, my lord.
Page 55.
Yes, my lord. That is P3, standard terms and conditions.
Page 55.
Yes, my lord. It starts at page 55.
Page 55 is balance sheet.
Oh, God. Again.
4340. 4340 I am looking at.
Kindly allow me one moment. Where is the contract starting?
The pages are differently
I apologize, my lord.
stitched in different.
Yes, my lord. It starts at page. Again, when I invite the tribunal to take the report to take the
In 43, we are looking at 4340 now, which is 4335 of yours.
Yes, my lord, can you take page 75, my lord? I sincerely apologize for this confusion, my lord. Take out the corresponding clauses. Clause 3.40, Nicola.
Page 75.
Yes, my lord. Starts at
P3.
3.40.
It's annexure P3.
Yes, my lord. Clause 3.40, my lord, is cartel formation.
Just a minute. Please.
That is, my lord, at page 92.
Please give me a moment.
I'm sorry, my lord. Procedure for penal action. There's a 275. And where it is. Don't have the content.
Yes.
My lord will kindly see 3.40 cartel formation. My lord, it says cartel formation or quoting of pool rates, page 92 হবে sir. Cartel formation or quoting of pool rates or quoting in collusion is against.
Just a moment.
I'm sorry,
Page 92.
lordship. Yes, my 92 bottom.
Page 92. 3.40.
Yes, ma'am. 3.40.
3.40.
18. आगे पता नहीं.
Cartel formation. Very well. Yes.
My lord, it reads cartel formation or quoting of pool rates or quoting in collusion is against the basic principles of competitive bidding and shall attract penal and punitive measures, including suspension, banning of such bidders for a specified period as per, kindly note my lord, as per the procedure for penal action in OF units. OF is Ordnance Factory of OFB under the guidelines of the Ministry of Defence for penalties in business. So my lord, this procedure for penal action and the guidelines of the Ministry of Defence for penalties in business, these are my lord parts of the contract. I will have to take your lordship through that.
Please take me through that.
Yes, my lord. So my lord, your lordship will find that the contract only says that I am to be disqualified if there is, my lord, price collusion or collusive bidding found. Quoting of pool rates, that is, my lord, the salient term. Thereafter, if your lordship will kindly take the procedure for penal action, which your lordship will find at page 94. Sir, 74. Kindly see, my lord, this is the cover page. This is, my lord, Government of India, Ministry of Defence, Department of Defence Production, Ordnance Factory Board. My lord, the relevant provision is clause 7.50.
7.50. Where is that?
I'll only one more. Huh? Yes, my lord, page 223. Sir, 223. Penalties, my lord, 7.5. All contracts where.
Just a moment. Page 223.
Lordship.
Two to three.
Does your lordship have it, my lord? Clause 7.50 penalties.
Page 223 has something else. Page 223 has clause 10.2, 11 and 12. Clause 7 is somewhere at page 221, but then it is only 7.1 and 7.2. Then clause 8 begins.
203. I sincerely apologize for this, my lord.
203 is there. Yes.
Yes, lordship. Penalties. I sincerely apologize for this confusion, my lord. May I read it, my lord? All contracts, whether with domestic or foreign vendors, will have provisions for suspension or banning or debarment. The existing guidelines issued by the Ministry of Defence, vide ID number such and such, dated 21st November 2016 and 30th December 2016, or revised time to time, for penalties in business dealings with entities and the suitable procedure SOP for levy of financial penalties or suspension banning of business dealings with entities promulgated by the OFB, that is, my lord, Ordnance Factory Board, should be followed. Action may be taken by the head of department by issuing a show cause notice to the firms, and after due consideration of all relevant facts and circumstances of the case, an appropriate decision may be taken. The reasons for the decision should be duly recorded in detail if the head of the department is of the view that the gravity of misconduct justifies penal action involved more than one factory unit, then the case shall be referred to, kindly see, my lord, concerned operating division for appropriate action by the competition authority, by the competent authority. So, my lord, competent authority, now I'll have to show your lordship. Next, my lord, I'll have to show your lordship these guidelines for penalties in business. That is
Page.
well, 1 minute. Well, let me check and then tell your lordship. Index maybe. Right. Can you see page 265, my lord, perhaps?
So 4335, 4340 has become irrelevant because you have a mixture of both.
I don't know, my lord. I can only sincerely
265
apologize,
is,
express my embarrassment.
is guidelines of ministry.
Yes, that is what I'm trying to place, my lord. I'm grateful for lordship bearing with me, my lord.
No, why? It's my duty. I can't be rash. It can happen with anybody. Yes.
So, my lord, this is also part of the contract as I showed your lordship. Here, my lord, if your lordship will kindly take clause 8.3 at the bottom of the page.
B.3.
B.3, yes, my lord.
Yes.
All firms/companies which come within the sphere of effective influence of the entity shall be treated as allied firms. So, my lord, there is a notion that two firms may be allied firms, and then that is defined. In determining this, the following factors may be taken into consideration: whether the management is common or the majority interest in the management is held by the partners or directors of the entities. 2. Majority shares are owned by the entity, their directors, shareholders, and by virtue of this has a controlling voice. Lordship has seen the show cause notices and the order of disqualification and blacklisting, my lord. There is no allegation that, my lord, Naveen Tools, with whom I am alleged to have colluded, is an allied entity. Within the meaning of, my lord, this guidelines of the Ministry of Defence for penalties and business dealings with entities. So there's no allegation to that effect. If your lordship will then kindly see B5, competent authority is defined.
Just a minute.
Page number 265, 266. May I place B5, my lord?
Just a minute.
Sorry.
Yes.
Yes. So, my lord, B5 defines the competent authority. Competent authority for the purpose of these guidelines is the Raksha Mantri. So, ultimate say so, my lord, is of the defense minister. Lordship has seen, my lord, neither the show cause notice nor the order of blacklisting mention that it has been done, my lord, under the imprimatur of the defense minister. There's no signature of the defense minister. B6, the competent authority may constitute a committee as necessary to examine and make recommendations on any matters provided for under the guidelines. Kindly see, the show cause notice and the blacklisting order are not issued by either the defense ministry or any committee constituted by him. It is, my lord, issued to me internally by the respondent, that is Gun and Shell Factory, Kashipur. Then, my lord, C, under B6, causes for suspension and banning of business dealings with entities. These are the grounds on which they can take penal action against me.
Yes.
C1, the competent authority may levy financial penalties and/or suspend/ban business dealings with an entity for one or more of the grounds listed below. A, violation of pre-contract integrity pact. That is not the case here. B, resort to corrupt practices, unfair means, and illegal activities during any stage of the bid contract to secure a contract, even in cases where PCIP, that is the previous, my lord, pre-contract integrity pact, is not mandated. C, violation of the standard clauses in the contract of agency commission. D, if national security considerations so warrant. E, non-performance or underperformance under the terms and conditions of the contract or agreements not covered in the grounds listed in A to C above in accordance with the provisions in contract or arrangement. F. Any other ground for which the competent authority may determine that suspension or banning of business dealings with an entity shall be in public interest. So, my lord, I don't fall within any of these. The contract tender document only says, my lord, if there is collusive bidding or pool bidding, I can be disqualified and, my lord, penal action can be taken against me. Now, my lord, I will show your lordship the chronology. They have proceeded to issue the show cause notice to me and ban me before the price bid is even opened. They don't know how much each of us have bid.
Yes.
And there is no, my lord, kindly allow me to finish. My lord, one or two things more I have to show
No,
your
I'll
lordship.
have to call for a report. Let them come with a report on this.
No, my lord, but there is no personal hearing given to me. And kindly allow me to only show your lordship the chronology.
Let them first justify their authority.
My lord, before the price bid is opened, they call me to be colluding on
Very well. I'm calling for a
collusive
report.
bidding.
I'm calling for a report. It's not that I'm sending it for hearing or I'm not interfering with.
My lord, I will file a report. My learned is subject to things. Number one, it was blacklisted, and there is a rules that one company can be applied for the bid for one item only. Either
Where is that rule?
That rule, my lord, I have not found anywhere, my lord, with utmost humility.
Number one. Number two, my learned has given the regulation number 2018. We has taken in the 23-24. And after that,
Yes.
There are different regulations in 23. Show me.
I am not a comment, but I am one. Only 60.5 penalty.
Can you give me a copy, sir?
Sir, this is a matter of defense. We cannot allow anybody for little fraud and more fraud.
Nah, but sir, you're showing. My lord, may I be furnished with a copy? I don't know what is being placed to the court.
Please give a copy. Since you are placing it before the court, they should have a copy of that.
Allow me to read it from here. I don't know what is being addressed to. 7.5.
Just from the first page. He has filed the rules of the 18.
So competent authority is no longer there.
No. I have the right. You will file a report.
Kindly allow me to show your lordship only the chronology, my lord. Before the price bid is opened, they say I am disqualified because there's collusive bidding.
I will in any case have to see the report, because without the report I will not immediately allow the writ petition at this stage.
My lord, at least the banning can be stayed. I'll tell your lordship why I'm.
The banning stage will amount to final decision at the interim.
It shall not, my lord. What is happening today is I cannot participate in other tenders.
Suffered it for so long. For 2 more weeks, nothing is going
Very
to
good.
happen. For
Very
2
good.
more weeks, let the report come.
Very good.
And since now it is apparent that there is a different guideline, let that also be placed on record. Let us see what happens on that.
Guideline also cannot permit, my lord, blacklisting on the basis of price pooling or collusive bidding without opening my price bid. It's absurd. With utmost respect.
It may not be only on the basis of price pooling, because price pooling is one of the several criteria.
In the
One
contract
of them was
document.
cartel also.
Yes.
Now, whether bidding through the same IP would amount to cartel formation or not, that is also a question to be pondered. The reason for which you have been blacklisted
Yes.
is not price pooling. Price pooling is one of the reasons which is there in the list,
Lordship.
which shows that these are the reasons for which you can be blacklisted or
Yes.
banned.
Yes.
Now, out of that, the other reason is cartel formation also.
Yes.
Now, whether applying through the same IP,
Yes.
using the same IP,
Yes, my
would give rise to a justified suspicion that there may be cartel formation,
Yes.
or not, is a question.
I can address your lordship on that right here, right now.
Very well, but then I'll have to elicit their response also on that.
Very
I
well.
cannot immediately state and proceed, because
My lord,
there has to be something. See, these are very sensitive matters where ammunition, arms, all these things are involved, and you are supplying it.
I appreciate, my lord, but from page 400 onwards, my lord, I have included, my lord, the eligibility criteria and other tenders, my lord, issued by other procurement organs of the Ministry of Defense,
Very well,
other
we
than
shall
Gun and
go
Shell
into
Factory,
it.
Kashipur. I cannot place any bids.
Because as of now, I don't have anything from their side in support of whatever defense you are taking, because it stood admitted by you that yes, your IP was used.
Yes, IP
You
is
may
the
have
same.
very good reasons for allowing them to use their IP.
Yes.
But whether those reasons were sound enough to cross the threshold of cartel formation or not, that is to be seen.
There's
That
nothing,
cannot be
nothing in
that-
the regulation or in the contract which says, my lord, I
no,
cannot
the
bid from the
regulation that you are citing
same
as of
IP
now
address.
appears to be outdated. Now, what is there in the present regulations? Even you have not placed.
My lord,
before the
kindly
court.
abridge the time. We will come back, my lord. Kindly
That is why
abridge the time.
we cannot at the threshold.
Very well, my lord. Kindly abridge the time because I've been suffering for
that
extremely
will
long. My business is completely, my lord, disintegrated.
Likhani. This writ petition lays challenge. Acha, what
It may have some precedence in the list, my lord,
Yes,
because
it
I have been
will.
suffering for a long
It
time.
will have,
Only
it
that,
will
my
have.
lord. And my lord,
এটা for further consideration হিসেবে 30 January for
And my-
further consideration ই বলেছি তো, it will appear.
may I pray for one more liberty, my lord? May I inspect your lordship's records to, my lord, tally my petition pages? Otherwise, my lord, I will face similar embarrassment on the return of it. I certainly shall, my lord. If I rectify my petition, I will serve a revised copy to my lord, senior friend. My lord. Extremely grateful.
Thank you. দিদি এই দুটো ফাইল আছে দেখে নিন। Yes.
My application before your lordship, my lord.
Under calling number 2 and 6. He could have problem, so I'm paying for not today.
My lord, pursuant to your lordship's earlier directions, I have served the state respondents
Respondent
also.
number 6 was supposed to be served. No?
Yes, I have made my endeavor to serve and they have received it.
A report was supposed to be filed by 2, 3 and 6. You are appearing for which respondent? And 6, who is appearing for 6?
My lord, I do not see anybody, but I have served them. I am not seeing anybody, my lord, but I have served them pursuant to your lordship's earlier directions.
Very well. I'm recording an order. Since she is also praying for time.
Yes, my lord. Since this petition related to, my lord, disbursement of the final bills, my lord, kindly to fixes any date so that.
While the petitioner, no, লিখুন,
My affidavit of
an accommodation is prayed for, affidavit of service filed on behalf of the petitioner is of service to me.
Appearance term of the bill. Great.
Next.
Lordship, Mr. Shobhoshatri Bhattacharya is appearing in this matter for the petitioner, Lordship. He has not present today due to his personal difficulty. I'm praying for not today, Lordship.
Not to go.
Grateful.
You want an order to be recorded? Yeah, order record. An accommodation is prayed.
My lord, I'm appearing for the respondent. Petitioner for deputy prosecution. because I'm filing with both my lord and it exposes the mention. So
দেখি দিদি ওটা উনি দিচ্ছেন দিদি
issuance of transfer by
লিখুন none appears for the petitioner full stop learned advocate appearing for the respondent
gratefully. And then 41.
yes not today good
And then 42.
not today
And then 43.
No, I'm for the petition.
yes দেখি দিদি
But this is my ability website. But this is a second writ petition, my lord.
yes
My lord, point is involved, my lord, in this writ petition, my lord, that the petitioner's mother was a temporary casual worker, and my lord, according to state government, my lord, there is a provident fund, and my lord, in the nominee of the provident fund, his name was written as Utpal. Name is written of my lord. Name is written, my lord. Ujjwal Rai, my lord. Instead of Somnath Pramani, my lord, is the name of Ujjwal Rai. My lord, his mother also filed an affidavit and also made an advertisement in the Ajkal Patrika. That is due to mistake, my lord. The name was written as, Lord should kindly see the affidavit, my lord.
What is the problem, Mr. Bhavik? Now what has
Problem,
happened?
the problem is, my lord, he had denied to pay his legal dues on the ground that your nomination is not your name. But my lord, he ignored the affidavit and also advertisement of the.
Very well. We serve a notice on the learned government pleader's office
Well,
and keeping it on next day because they are required to be here. No, I don't know if somebody has already been let him serve a notice on the government pleader's office.
No, এখন নিয়ে আমাদের।
This
Already I have served the copy.
this writ petition seeks issuance of a writ of mandamus.
হ্যাঁ
Today. Not today. Please did the
account is being frozen by the Tangra branch of the Federal Bank. Pursuant to Malone instructions received Malone from the Rajasthan police.
And what is the reason? Fraud. Liken it. None appears for the petitioner. Not today.
My lord, I am appearing on behalf of estate, my lord. In item number 48,
648, you are appearing.
my lord.
Very well.
My lord, may I allow to submit my report, my lord?
No, no, the petitioner is not there. Please wait. You are appearing for the state. What is the report? Show me. देखिए तो दिन
First, second, and last paragraph, my lord. These three paragraphs are the vital one.
Very well. None appears for the petitioner. Full stop. Learned advocate. Learned advocate appearing for the state respondents. Hands up to court. A copy of the instructions forwarded to him by the executive engineer -1, Canals Division, Irrigation and Waterways Directorate, Government of West Bengal, and submits that the hoardings put up by the petitioner had been dismantled since the same were put up on the land of Irrigation and Waterways Department of the Government of West Bengal. That is it?
My lord, I have given permission to do and taken the revenue.
Very well, very well. Since the petitioner is not represented, list this matter under the heading for dismissal on January 13, 2020.
Deeply obliged, my lord.
My lord, our matter is in group 4 urgent matters. Will it be taken up, my lord, today? Because the opposite side is not present, my lord.
After this is over, I'll go back.
Okay, obliged.
The assigned hearing matters will be taken up today, my lord. Assigned hearing.
Hearing
item number.
matters, yes, serially I'll go there.
Okay.
Serially I'll go. I'll come back in 5 minutes. Not today. Not today.
651, my lord, I am appearing on behalf of the petition.
Why?
I have a extra brief. I have an extra brief. You can take it. My lord, here in the petition, my lord, the petitioner seeks certified copy of the deed which is presented in the year 1990,
Yes.
where the state respondent has apprehended that forged stamp paper may have been used for the purpose of registration. And to that context, the state authority already initiated a criminal case against the stamp vendors. That criminal case is still pending. In the meantime, Honorable Division Bench already passed an order to supply the certified copy of the deed upon furnishing the aggregated deficit stamp duty. This is the order of the Honorable Division Bench. And in this context, already, my lord, in this context, my lord, already your lordship has already passed an order on the similar facts of the case, where your lordship has already allowed to petitioner to deposit the aggregated stamp duty.
Yes, sir.
After order by just received the order, but now number 3 of my lord's order. I see that the state had earlier submitted that the certified copy may be.
Yes, but do you make the same submission? You want to come back? I'll put it.
My lord, I may have some instructions.
Let him come back. Let him come back. Not next Friday, then I'll keep it some other day in the week itself, so that we can finish it off. Lieutenant, the learned advocate appearing for the state respondents seeks some time Yes,
My lord, in item number 652, I am praying for not today.
not today. Next. Not today. Cholo. Not today.
Your Lordship, I'm for the petitioner. I'm praying for not today.
Today.
Great.
Oh,
So the allegation, is that allegation against the local panchayat and the
ঠিক আছে order record করে নিন. None appears for the petitioner. None appears for the petitioner. Not today. Not today.
Regarding the encroachment on the national road. So already there is a subsisting order on Justice Ultra Banerjee. And potential.
But they want implementation of the order. They want implementation of the order. You keep this report with you. The petitioner is not there. None of देखिए की আছে ওটা যেটা 9th বললাম না আচ্ছা থাক ওটা 9th থাক
Sixth minor.
না 9
Two matters will be decided minor.
It is specially assigned. Who said it is not assigned?
Especially as a minor, but
Yes.
but that matter also
So what?
coming to party.
Why? I was also coming. I was also on that side. I used to come. Come one day.
My lord is no, my lord is great, my lord. Idea.
No, no. I used to come. I had matters in 659, in 759, then in code 19 also.
And you got 6 months.
No, that cannot be a ground. None appears for the petitioner. Full stop. You are appearing for the respondents all. They are all state respondents. চলুন।
Yes.
Thank you. Same to you. Serially, the indication in the list is after that we'll go serially. I'll go serially.
My lord, I am appearing for the petitioner, my lord.
Respondent
They are not present, my lord.
won't be proper. Today
No, my lord. If it could be kept on 5th.
has to be on 5th, not
Yes,
same
yes.
5th, not today. What is the matter?
My lord, it's a matter of excess ITC availed and excess output tax shown. The urgency is because the recovery notice has come and gone to the bank.
You want an order to be recorded?
No, my lord. I have 3 and 4 also. That's
Achha.
same. My lord.
Same, not today.
Opposite
Not
side. is not.
today. EGST is involved. Or
Yes, my lord.
SGST?
In one matter, CGST is also involved.
The other two are SGST.
Yes, my lord. Obliged, my lord.
ফাইভে একটা অর্ডার রেকর্ড করে নিতে না কেউ নেই তো কি দেবে না না পিএস ফর দি দেখি দিদি একটা ফাইল দিন তো কিসের জন্য মেনশন হয়েছিল 6 টু ইয়ে একটা যে কোনো দিন আমাদের 18 তো থাক নট টুডেই থাক কারণ আর্জেন্সি গ্রাউন্ডে মেনশন ছিল তো আবার সোমবার নট টুডে করতে না সবকটাই ওই অর্ডারটা হবে না নট টুডে 6 থেকে 10 অবধি নট টুডে করে 5ও হচ্ছে না সবকটা নট টুডে করে নট টুডে সবাই হয়তো ভেবেছে যে স্পেশালি অ্যাসাইন গুলো চলবে বলে আসছে না করা ঠিক হবে নট টুডে
Topon boundary is on the other side. My lord, this is a matter regarding service tax. There are two major issues.
He's not there.
But it can be.
No, not today.
Well, he said that he's in legs on another court number
If you
34.
can bring him, I'm making it pass over. I'm passing it over.
Keep it pass over if it doesn't come.
Passing it over. Let him come. Pass over correct.
Well, let's make it not today because he said it to make it hard.
Not today.
15 and 16.
15, 16, not today.
16 and 17.
Not today.
But 18 is my application. The other side is not here. But here, the entire amount has been deducted. Auto deduct. My appeal under section 112 is there. The statutory provision is there. In spite of that, they had get the entire amount. They had given me a hearing on 4th December. And that date, they said that no, we will not refund you anything. Instead, we'll also take out the penalty and the other interest part also. So, I was before Lordship. I mentioned this matter. Lordship directed the matter to upgrade motion. So, this is the situation. The difficulty is that the appeal under section 112 also cannot be filed because of the staggering mechanism. The president of the appellate tribunal has already stated that before 1st February, no appeal can be filed. But I am not on that. I am only on that. Let them deduct the amount that I am supposed to pay at the time of filing and refund the amount and let the appeal be heard. That's all. Let them come. Only thing I was beseeching your Lordship, let the matter retain its position. So on Monday, I can. I'll come and.
Today means nothing is happening.
Yes, I'll come and satisfy your Lordship's court, my lord. Much obliged, my lord. Grateful to your Lordship's court.
Thank you. Not today.
Millards, item number 19, Millards, I appear. Millards, I request, Millards, as no one is present, Millards, I request not today.
Not today.
Much obliged.
Your Lordship, Mr. Obro Mojumdar is appearing in this matter. Is on his legs in court 759.
Not
Kindly
today.
bring.
Not today.
I'm for the petition. My lord, against an attachment order, your lordship, and money has been transferred from my bank account to the electronic cash ledger. My lord.
Not today.
Great.
কল করে যান হ্যাঁ দাঁড়িয়ে আছেন কল করুন পাস ওভার করুন পাস ওভার পাস
My lord, I'm for 46 and 47, my lord.
Not today.
Not today, but my lord, since it's a matter, I'm a society and the money is deducted from my account. I'm having serious issues with my finance. So it could be kept.
46 and 47?
Yes, my lord. DKT.
এটা আপগ্রেডেড করে দিন ওনাদের প্লিজ গিভ নোটিস টু দেম
Yes, my lord. Obliged.
হ্যাঁ $46, $47 আপগ্রেড করে দিন
48, 49, 1, 5, 8, 9, 6, 1, 4,
Your Lordship, in case of serial number 87, I am praying for not today on behalf of
87 not today করবে।
not today. I am grateful, Lordship.
চল চল।
My lord, 103, not today. As the opposite side is not there.
103 not today করবে।
But I'm for the petitioner, my lord. On the last occasion, Mr. Duduri appeared for the respondent. He took time on the ground. He will take the instruction from the department.
106
106 is a Bankura district.
what was the matter?
There is two PAN, my lord. Only one, my lord. We have to submitted return in the subsequent PAN, my lord.
Oh.
And they are saying that we have not surrendered, so therefore it can be added as. We have already same amount has been already been filed return and assessed, my lord.
Oh.
They have issued the 148 AV notice, and we have filed a
Today
reply.
is not there. Let us see.
Yes, man. I'm not just for so that man kindly maybe update it. This is a bank. They are facing difficulty, man. If my lord from then, man, I'm not.
Very well. Let 1 or 2 days go there because it's down in the list. I'll upgrade it. After 1 or 2
And
days.
it was
again,
it
you
was
can-
and it was taken up once, man. That is why otherwise.
It was appearing as an urgent motion.
No, it was taken up by my lord once. And then my lord he took time and.
देखिए औरत देखिए 106
What are and it was no order has been passed. My lord, he first time he took time.
No, but if I pass an order granting time to take instruction, I pass an order.
Maybe I don't.
That is usual practice.
Yes, yes. My learned friend appeared,
Whenever I grant time to take instruction, no, it was not taken up because.
Okay. Well, he is not carrying his brief today.
Making it not today. Once it is, you mention it for upgradation, and there is no order here.
Which will come on the
That's it. Not today.
8 no 108 not today.
Not today. 118.
$126 not today. So you are appearing for the respondent. Then don't pray for not today. Let them come. If they don't come, I'll make it not.
Not today, sir.
133
133.
not today.
I'm the petitioner.
Today. 136, not today.
My lords, I'm for petitioner for 138, my lords.
Not today.
Not today. The other side is not there. Obliged.
Nobody is there for the state and union today. Nobody has appeared. They thought that specially assigned matters.
Yes,
is
my lord, even we are under the impression.
because they are lessening day by day, so they may not continue for the whole day.
I'm the petitioner, my lord. In this matter, the petitioner do not want to proceed with the matter, my lord.
Achha.
My lord can
To be mentioned, I
to
mean.
be mentioned, my lord.
It to be mentioned, 142.
Yes. I think Mr. I will serve the notice to the respondent.
And bring that
Yes, sir.
instruction.
Yes, yes.
There. Not today. Not today.
Not today. Not today. Not today. Not today. Not today. Not today.
I'm praying for not today, Your Lordship.
Not today. All matters will be not today, I think, today. Nobody is there.
Same, Your Lordship.
Not today. Not today. Well, not today.
Lordship, I'm praying for not today. Your Lordship, not today. 70. Sir, not today. Not today. Not today.
All those matters where only on the ground of delay appeals have been dismissed, or matters which are similar which are similar in nature. Those matters, if you can hand up a slip, we can have it clubbed under a particular heading. It will be easier for us to decide.
Yes,
where the delay is not more than 100 days. There we can dispose it off.
Where the delay is more than 100.
Then costs and all these things are there.
So, then up to 100 days delay, we should have.
Yes, if we have that, then in that case, which are there in the list, we can arrange it. Yes, and registration cancellation matters which are already covered by earlier orders of the division mentioned. Then we can dispose of a few matters. Unnecessarily, those are also clogging up the list.
We were just discussing that.
Because at times under urgent matters also those matters come up. It takes at least 5-10 minutes for us to finish that off. That can be devoted to other important matters. I'm not saying those are not important, but that can be disposed of in one go.
May I humbly submit one thing, my lord? If those matters where delays are more than 100 days, if those are included in the same list, but the heading should be the delay is more than 100 days.
No, that
On one shot, my lord,
heading will not give that way because that would look nice. If you give the numbers, we'll accordingly bring it in the list. You give us the list so that while we formulate our list, because when we arrange our list, we'll be arranging it in a proper fashion so that we can touch those matters when we have little time.
my lord, my lord.
So that greater time can be devoted to matters which are urgent in nature and which require a hearing.
Yes.
Those matters don't require a lot of hearing
Yes.
because those are settled now
Yes.
by judgments of this court.
We'll do that. We'll coordinate and we'll give it.
Not today.
Delay which marginal delays, 4 days, 5 days, 20 days, those can be done away with so that merits can be touched upon.
— 177 and 70. I'm praying for not.
My lords, I am for 179 and 180. Praying for not today as opposite side is not there. Problem.
My lord, praying for not today. 185.
In case of, excuse me, in case of 198, I'm praying for not.
Probably not today.
Not today.
My lord, there is no respondent right now, either from the state or from the
Yes. Nobody has come to court or they are
No,
in
my
some
lord,
other
for
court.
income tax, my lord, everyone is there, my lord, in the code number
So income tax
759.
matters are not there, no, in the list.
There is a matter, my lord, only
They are later down the list.
today, my lord.
I'll have to sit. I'll have to call. If nobody responds, then only I can rise. কল করে যান যদি কেউ না থাকে তাহলে কি
204 not today.
বসে যান, বসে বসে কল করুন, দাঁড়িয়ে থেকে কল করে লাভ নেই, বসে কল করুন।
My lords, I appear for the petition, my lords. Issue involved is a very short one, my lords. It is only about that the order is a non-speaking one. I know other side is not there. Just that it is non-speaking one on the so it pertains to refund along with interest I had claimed. No speaking order on the interest piece, my lords. Nothing on interest. Although the tax was paid way back in 2010-11, refund was granted in 2025. Nothing on interest. So that is my limited prayer, my lords.
Nobody is there.
I know, my lords.
Yes.
$211 not today. 213 also not today.
My lord, praying for not.
119 not today.
230 not today.
Your Lord, 245 not today.
Not today.
$265 not today. Lordship, I'm praying for not today.
91 not today.
$293 and 4 for not today.
Not today could be.
$303 Lordship. This was withdrawn long ago, Lordship. In the month of March, I am carrying the copy of the order.
দিদি দেখুন এটা কেন লিস্টে অ্যাপিয়ার করছে উইথড্রন ম্যাটার অ্যাপিয়ার করছে ফাইল আছে 303 এর ফাইল বার করে রাখুন ফাইলটা তাহলে দেখে নিয়ে লিস্ট
Yes.
এটা ডকেটে কেন দেখাচ্ছে পেন্ডিং তাহলে at 2 p.m. I'll regularize it. ফাইলটা বের করে রাখবেন
Lordship.
Next.
Your Lordship, item number 304 to 311, I'm praying not today.
Got 304 to 312.
311, Your Lordship.
311, not today. 303 টা আনবেন 11 of the not today.
Your Lordship, praying for not today.
300,
318 and 319.
18, 19, 20, 20, 21, 22,
Yes, yes, sir. Till 322, I'm praying for not today.
318 to 322.
Grateful, Lord. Your Lordship,
It's not today.
Not today. 333 not today.
3:35 also.
335 not today. 334 call.
Forty-one, 42 not today.
41, 42 not today. What are these matters?
Your lordship will have to pick on.
Very well.
Not today. Not today. Ship 346 is already updated, but gradually it is in the downs. 346. The
It was
urgent matter.
appearing as an upgraded.
Yes.
When?
Last week, in the month of 23rd December.
23rd December, if it was appearing as upgraded, it cannot come down in the list.
This
We
matter was
definitely
this matter council was Devashish Ghosh is appearing this matter.
Maybe, but I
His
don't think
mans-
that it was এটা দেখে নেবেন তো দিদি 346 একটু দেখে নেবেন আপগ্রেডেড হলে এত নিচে তো চলে আসবে না দেখে নেবেন very well we shall check it
Today I also mentioning updates.
না না বলছি আগে অ্যাপিয়ার করছিল
My lord, 361 not today.
not today
368 to 372 not today.
The 373 for the petition, and your lordship.
By 385 and 386, Your Lordship. Lordship, these writ petitions, my lord, we filed, and we filed certain similar writ petitions for other entities as well. And what has happened in all these, in the writ petitions, is that, my lord, assessments were conducted. Subsequently, Your Lordship, we preferred an appeal. These are matters pertaining to transfer pricing also. So, my lord, earlier the transfer pricing officer proposed an adjustment. It was confirmed. We preferred a application before the dispute resolution panel, but which is basically similar to the CIT appeal proceeding. Then, my lord, he passed certain directions. The matter was thereafter those directions were given effect to by the transfer pricing officer and the assessing officer. Against that, Your Lordship, we filed an appeal before the tribunal. Your Lordship, tribunal has granted a substantial relief. But, my lord, certain directions were to be carried out in terms of certain computations. So, my lord, a decision. So, therefore, these give effect orders were to be passed by the assessing officer in terms of section 153, subsection 5. And that provides a certain time period within which these give effect proceedings are to be completed. Now, my lord, these give effect orders, despite multiple reminders from the assessee, but give effect orders were never passed by the assessing officer. Now, my lord, the law is that if the assessing officer does not pass the give effect order, then, my lord, the return becomes final and the returned income becomes final. So, your lordship, therefore, I am in fact, in these cases, entitled to certain refunds because my return income has become final and department has made certain adjustments on the basis of certain refunds for other years. So my lord, in this writ petition of item number 384 and 385, your lordship, this is the central issue. My lord, we had also filed certain other writ petitions for another entity in the name of Sikka India Private Limited. But there the department was asked to take instructions. But an order was passed by this honorable court in on 11 June 2024. But I'm humbly praying that my lord, if all these matters can be taken up together, because my lord, some minor facts may be here and there.
Those
slightly
matters
different.
are there in the list.
But they are not even in the list, your lordship. So my lord, if those matters can be included in these matters, because my lord, even on the original side, my lord has fixed one such matter on 6th, my lord. My Lord friend Mr. Sharma is appearing on the original side, your lordship.
So if the sixth matter is done away, I mean, is concluded in one way,
My lord.
then that will govern these also.
Yes, your
if
lordship,
the point
because-
is same.
Because my lord,
So
the
let
point
the
of law is
sixth
same.
be decided, then you remind me, I'll upgrade it and decide it accordingly.
Yes, your lordship. That I'm obliged, your lordship.
Thank you. Chalo.
Three 386 are identical.
Very well. না না আপগ্রেড করতে হবে না 6 তারিখে একটা অরিজিনাল সাইডে ফিক্সড আছে ওটা হয়ে গেলে এটা তাহলে আপগ্রেড করে ওই হিসেবে ডিসাইড করে
Your lordship.
once the sixth matter is over,
My lord.
the matter fixed on 6th is
My lord.
over, we'll get an idea of how to go about it.
My lord.
Then we can decide all these matters in similar lines.
My lord. And I'll also, in the meantime, if I may mention the matters on Monday, the ones which are not listed, so
Yes,
that
yes.
they can be included.
Those will be included.
I'm grateful.
Chalo.
Praying for not today.
Grateful.
Not today. This matter, today I mentioned. Today I mentioned this Garnishi bank record.
Very well. You mentioned it will be upgraded.
Yes.
Pilot 412, not today.
Not today.
Your lordship, I'm praying for not today. 420.
Four 436, Your Lordship. I had mentioned this matter today morning for upgradation.
upgradation, it
Yes,
should be
it was the challenge to 148 AD order. So we can do it at 2 p.m. if Your Lordship may keep it at 2
If
p.m.
your other side is there. Other
Mr.
side
Tilak
is-
Mitra, I had served notice upon him for mentioning, but
if
I
you
don't
can
think
bring
he's
your
here.
other side, then in that case I can do it. And the other matter which you mentioned, there is a
That is for
incorrect-
21st. That is not in the list, Your Lordship.
Yes, so if you can bring your other side only, then I'll, because it's date.
Yes, yes. So
it
that two
will-
matters can be taken together.
No, not together. I'll have to bring it for correction, then correct the date only if the other side agrees to it. Because
Okay, Your Lordship.
dates, nobody will remember what it was 20, it was 02 or
Okay,
2.
I don't have any problem with that, Your Lordship. That can be taken on 21st, no problem. But the other matter, if Mr. Mitra
No,
is
if you
here,
feel that the date is important, it has to be preponed, then in that case, there has to be a judicial order. He has to be there. I'll have to bring it as to be mentioned, correct it, and then bring it.
Okay, no issues, Your Lordship. And item number 436, if Mr. Mitra is
436
here, it
will,
can be taken up at 2 p.m.
if he's there, he can take it.
Okay, grateful,
Definitely,
Your
it
Lordship.
can. If you can bring your other side, whoever is there.
Yes, yes.
Even Mr. Mitra is not there, maybe the panel has changed. Somebody else is there. Even if he's there, I can take it.
Grateful, Your Lordship. Your Lordship, 438 or not today, I'm paying for.
438 not today.
$448 also not today.
448 not today.
Grateful, Your Lordship.
There are not many income tax matters, very less income tax matters. Mainly it's the GST component.
Your Lordship, 459, Your Lordship, I in fact even mentioned the matter. There's some urgency that is now happening in the matter. But actually, what has happened is, my lord, for the assessment year 17-18, my lord, the department had made an assessment wherein they raised a large demand. Against that, Your Lordship, I've preferred an appeal before the Commission of Income Tax Appeals. My appeal is still pending as on date, Your Lordship. In the meantime, Your Lordship, the department has initiated from time to time recovery proceedings. My lord, they have issued notices saying that they will adjust. Say, my for assessment is 17-18 is the year wherein the demand has been raised. For example, in assessment in 1920, I was entitled to a substantial refund of about 4.5 crores. The department has adjusted that entire refund from the demand for assessment is 17-18. These adjustments that the department is doing, that is in excess of 20% of the tax demand raised for the assessment year 17-18. And despite objections being filed to these adjustments, my department is continuing to do it. So the case we've made out in the writ petition, my lord, is that firstly, the adjustment beyond 20% when the appeal is pending, that is not permissible in law. There are decisions of this honorable court in two cases of writ courts, my lord, of this honorable court, wherein, my lord, in such a case, the honorable court has been pleased to restrict the adjustment to 20%, giving a direction to the department to recalculate and to refund the balance amount. And, my lord, the second point would be that, my lord, if a
We
once
have made a prayer for stay.
my lord, we've made a prayer for stay subsequently, but, my lord, irrespective, my lord, there is a direction from the Central Board of Direct Taxes of 20%. And, my lord, once I've made an application to the department that you are adjusting beyond 20%, kindly do not adjust beyond 20%, remit the balance. My lord, in my humble submission, that prayer should have been considered. And secondly, my lord, after I made the prayer, which is in effect a stay application as well, department cannot make subsequent adjustments thereafter. And, my lord, another point that we've raised is that, my lord, once the recovery happens from refund by issuing a notice under section 245 of the Act. But once I file my objection to the 245 notice, my lord,
That has to be dealt with.
that has to be dealt with. In fact, my lord, there are decisions of the Honorable Bombay High Court which says that once an objection is filed, the department cannot make an adjustment at all, because there is no mechanism for them to thereafter deal with that objection and, my lord, to recover the amount, because, my lord, that objection is on record. So, my lord, firstly, they've not dealt with my objection. Secondly, my lord, they can't even make the adjustment subsequently. And, my lord, what has happened is, after filing of the writ petition, my lord, the department has made further adjustments after the writ petition. So, therefore, we are aggrieved in the matter. I would humbly pray
Upgradation.
that the matter may be upgraded.
We'll serve a notice on the other side.
I'll serve a notice, my lord.
সেটা 459 দিদি 459 আপগ্রেড করে দেবে notice serve a notice.
But if a date may be given, I'll indicate a date in my notice of service today itself.
Say that it has been mentioned for upgradation today.
My lord.
Keep a watch on the list.
My lord,
it may not be tomorrow, maybe day after tomorrow. I mean, may not be on Monday, maybe Tuesday.
I'm grateful, your
So you say that we have mentioned it for upgradation.
I will. I'm grateful, your lord.
এটা দেখে দিয়ে দেবেন। Very well, chalo.
My lordship, 491 not today.
এটা কি ম্যাটার দিদি? 491 টা ট্যাক্স ম্যাটার? এটা একটু বের করে দেখে নেবেন তো, দেখে মনে হচ্ছে না ট্যাক্স ম্যাটার। হ্যাঁ, তো দেখে আমাদের ডিটারমিনেশন না থাকলে ফালতু রাখবেন না। নেক্সট।
Five 15 and 16, I'm praying for not today. I'm grateful. $528 and 20. 20, not today.
My lord, 542 not today.
$563 not today.
Well, I'm for the petition of 570, my lord. What happened in this case, my lord? The prosecution has been launched, my lord. They have passed the order, sanction order passed under section 279, section 1. Read with they for the filing of section 278B, my lord, for the purpose of filing complaint. My lord, what happened in this case, my lord? We have deposited the TDS, the subsequent to the prescribed limit provided under the rules, my lord. But that has been deposited within 1 to 12 months. There is delay has been caused. But before filing of return, we have deposited along with the interest, my lord. My lord, it will be infructuous if my lord can be taken up early. So I'll
এটা আপগ্রেড করে দিন দিদি। Give a notice that it has been
yes, my
mentioned
lord.
for upgradation.
Yes, my lord.
It may not appear on Monday, but
Yes, my
in
lord.
the coming week it will be upgraded. The 570.
And 571.
570, 571.
Great, my lord.
এটা একটু আপগ্রেড করে দিন। একটু লক্ষ্য রাখবেন 4-5খানা আপগ্রেডেশনের মেনশন হয়ে গেছে এর মাঝখানে এটা নিয়ে
My lord, 583 and 585 not today.
not today.
82 and for the statement.
Yes, you can do it today then. State is present.
Mine is 83,
582,
583 and 585.
582, passing it over after this is this 583, 585 not today.
in praying for not today.
And 91, your lordship, not today. Yes.
Subletry is praying for not today. 606.
কল করে নট টুডে এটা করে দেবো কারণ এটা তো আজকে এমনিতেও ডেট নেই লোকে থাকবে না তাও সিরিয়ালি লেখা আছে যখন একবার কল করে দিন ওটা সব কটা নট টুডে করবো কারণ এটা তো পাস ওভার করার কোনো মানে হয় না
620
you're for the
respondent port trust.
respondent port trust. Nobody is there for the petitioner. Not today. You want an order to be recorded, Mr. Jana? Soon. Yes, those were called in the morning. We started from 6:24 in the morning. Specially assigned matters started from 6:24 at 10:30. You were not there then. That is why. Yes, if both sides are there, I can take up even today. Other side is there. First day of the year, why unnecessary direction of notice and all? देखी 629 টা দেখি 629 দেখি কল করে দিন 624 থেকে একবার কল করে দিন দেখি সেকেন্ড কল করে দিন এটা শেষ করে দিন যেগুলো কলড হয়নি You are for? Who is that? Oh. They have not gone before DRAT. Why have they challenged it here? Liquidation proceedings against whom? Orders passed in 2013 and 2022. लिखे दिन तो none appears for the petitioner. Full stop. One zero one.
101.
101. What has happened?
On 26/11/2025, your lordship has heard this matter. None appears for the respondent. Your lordship directed me to
What
serve
was the matter?
the matter. So, my lord, this matter, my lord, I'm a railway contractor, my lord. And now
It's a group 9 matter.
my lord,
Group 9 matter or revenue matter?
revenue matter.
Yes. Railway contractor.
Railway contractor, my lord. I'm under the purview of exemption, my lord. They are not giving it to me. Why? They are saying
Oh, that is why. So you wait. Your turn will come. What is the problem? Whenever it is called on.
if your lordship fix the matter under the heading. Grateful.
And that is appearing on 21st, then not a
Yes,
problem.
Lordship, the other side.
20. You don't have a problem on 20.
No, it's Lordship.
The other matter I'm trying to find out with the other side, I couldn't find out.
If you can bring him, I will take it.
Okay.
Grateful, Your
Grateful, Lord.
Thank you.
My Lord, I appear for the petitioner, my Lord. So this matter was taken up by your Lordship, my Lord, just on the penultimate day, a day before the vacation, my Lord. Subject to question, my Lord. Now, my Lord, here, my Lord, I have come up at the show cause stage. The reason why I have come up at the show cause stage is threefold. One is an audit proceeding was initiated under section 65 subsection 4 of the GST Act. My Lord, the law prescribes if section 65 subsection 4 read with section 65 subsection 6, the audit has to be completed within a period of 10 months. The audit was initiated on 2nd of May 2024 and it was completed, or audit report was passed on 9th of May 2025. That is beyond the period of 10 months. Now, my Lord, this audit report, my Lord, culminated into show cause notice. Now, show cause notice has been issued to me. So, this is the first round of challenge. Second is that the show cause notice has been issued under section 74 of the GST Act. Whether the ingredients or the show cause notice, my Lord, if your Lordship kindly goes through that, my Lord, it is now a practice of the GST authorities. Everything under the sun is issued under section 74. Though there is no ingredient of, my Lord, willful suppression, fraudulent activity, misrepresentation, it could have been issued under section 73 at best, but not under section 74. And thirdly, and most importantly, my Lord, now it is no longer reascending, my Lord, subject to correction, that 5 or 6 financial years has been clubbed together in one singular show cause notice. Now, there are authorities, my Lord, I have just brought only one judgment inadvertently, my Lord, which says that in one show cause notice you cannot club all the years together. My Lord, these are the three challenges, my Lord, before your Lordship. Now, my Lord, I'll just take your Lordship to that. I do not know what my learned friend's contention will be.
So your ground to the jurisdiction, your contention as regards the jurisdiction of the show cause issuing authorities, because
section 65 subsection 4.
So is there any consequence prescribed, Mr. Siddiqui, that if it does not happen under within 10 months, then in that case the audit proceeding will be scrapped?
No, that is my understanding, my Lord, if your Lordship.
Section 65.
Section 65. Audit by tax authorities. My Lord, section 65(4). The audit under subsection 1 shall be completed within a period of 3 months from the date of commencement of the audit. Provided that where the commissioner is satisfied that audit in respect of such a registered person cannot be completed within 3 months, he may, for the reasons to be recorded in writing, extend the period by a further period not exceeding 6 months. Well, the language further period not exceeding 6 months, my Lord, it implies that you cannot do any further. So 3 plus 6, 9. Well, I take it as 10 months, my Lord. For the purpose of this section, the expression commencement of audit shall mean the date on which the record documents called for by the tax authorities are made available to the registered person or the actual institution of audit at the place of business, whichever is later. Now, my Lord, why I said 10 months, if your Lordship kindly comes to section 65(6), on conclusion of audit, the proper officer shall within 30 days, that is 9 months there plus 1 month, inform the registered person whose records are audited about the findings, his rights and obligations, and the reasons for such findings. Now, my Lord, I'll take you to the relevant page in the writ petition. Pages 14 and 15, my Lord, is the initiation of audit proceeding. The starting date is 2nd of May 2024.
14 and 15.
14 and 15, my Lord. Page of the writ petition.
Page 14.
At the top, my Lord, it is stamp mark 2 May 2000. May. At the top, at the right hand side top, my Lord.
2nd May 2024.
2nd May 2024. Notice for conducting audit.
Yes.
Now the audit, after, my Lord, I gave reply everything, my Lord. The audit, my lord, was culminated into audit report at pages 43 to 47. This is the audit report under section 65, subsection 6.
Page?
My lord, 43, page 43. Page 43, my lord.
Yes.
It goes up to page 47. At page 43 at the top, my lord, you also may kindly see the date after the nomenclature and everything. 9th of May 2025.
9th.
Audit report under section 65(6). So admittedly, my lord, it cannot be, my lord, it is after 10 months.
But Mr. Siddiqui, if you travel down a bit,
My lord.
after the addressees portion is concluded, audit report number such and such dated 2nd of May 2025 is written. 2nd of January 2025 is written.
There is a report, but report under section 65, that is the internal communication. I am not aware of that. 2nd of January 2025, I am not aware of that. That is the internal communication. The report which was furnished to me under section 65, subsection 6 is 9th of May 2025. The report does not say anything as to why the date was extended. I received it on 13th of May. At the top, I have written it by through pen, my lord. I received it on 13th of May. But still, I take 9th of May.
9th of May, it appears to have been communicated to you.
My lord. So I'll take 9th of.
Completion may have been prior to that, because the section which you showed,
this
section 65(4) speaks about completion of the audit.
Right, my lord.
It does
Audit
not speak about communication.
No. 65(4) says, my lord, completion of the audit, and it has to be communicated to me on conclusion. Section 65(6). 4 has to be read with section 65(6). On conclusion of audit, the proper officer shall within 30 days.
So within 30 days from the date of conclusion. So if the conclusion is then also it's because if I take 1st January, the 2nd January 2025 as the conclusion date.
Right. Now then, my lord, it is within time. On the 2nd May, then also that there has to be satisfaction of the commissioner. I have not come across any satisfaction of the commissioner. Then also the time.
No, but there again, Mr. Siddiqui, satisfaction may be there in the file. You may not be
that may be, my lord, but I am not aware of any satisfaction because
the statute also does not oblige them.
That does not. But the audit report, my lord, nowhere in the audit report which was served to me under section 65(6), dated 9th of May 2025, my lord, it does not, my lord, nowhere it had discloses as to why the time period was extended.
And where is the notice under section 74? How do
Well,
you
notice
say
under
that
section show cause notice is at page 48.
48.
Lordship, may kindly see this is GST DRC 01. Tax period is April 2019 to March 2024. Has your Lordship got that? Page 48. I'm sorry, my lord, I'm going very fast.
No.
April 2019 to March 2024. Financial year is 2019-20, 2021, 21-22, 22-23, 23-24. Act is CGST SGST, issued under section 74, read with section 122.
The detailed notice is at
the
page
detailed notice
53.
is at page 53. At page 53. The show cause come demand notice, a huge detailed notice.
Why do you say it is lacking in the ingredients of section 74? There is no allegation of suppression or anything.
My lord, the allegation, my lord, I do not want to trouble your lordship with that. My lord, if your lordship kindly sees, but I have to read the entire. My lord,
no, because you say that the notice is lacking in the ingredients of section 74, then that has to be shown that the ingredients are not there.
My lord, I'll show to your lordship, my lord. But if your lordship kindly comes to the brief facts of the case starting from page 56.
Page 56.
Page 56.
Yes.
Well, the first paragraph is the inspection which they have carried out, the investigation which they have carried out.
Yes.
Number 2.2, on scrutiny of returns like GSTR1, 3B, 9 for the period so and so, ledger for sale gross equipment at so and so, statement having sale dated so and so, shipping bill copies bearing so and the provisions of notification, it is noticed that they have shown supply of goods. Has the lordship got that on the next page? It's shown supply of goods, namely circular lifting magnets and transformer at a concessional rate of duty of 0.10% to Messrs so and so. However, further scrutiny reveals that the shipping bill does not contain the details of the name and GST and supplier of goods and also details of tax invoice raised by them and mentioned. It is also revealed that another shipping bill number so and so only contains the tax invoice number and date, but does not contain the details of the name and GST and the supplier who happens to be the related party showing the premises. Now, as per the provision of the aforesaid notification, the registered and the exporter should indicate the goods and service tax identification number of the registered supplier and the tax invoice number issued by the registered supplier. But I have failed to indicate those numbers, the GSTI numbers, the tax invoice numbers. That does not make it a fraudulent activity, my lord. Export and has been export. The recipient would supply to the registered supplier of goods at concessional rate of duty. Now, my lord, the main bone of contention was the concessional rate of duty which I have sought. I may be wrong in seeking the concessional rate of duty. If your lordship kindly comes. Just I was checking it out. Take the concessional rate of duty. Or 2.3 at page 58. 58, my lord.
Page 58. 2.3, yes.
Lord, if you lordship 2.3 start from page 58, page 59, the last paragraph. In view of the above, and it's very. In view of the above, it appears that taxpayer had made domestic taxable supplies of the value of so and so under disguise of concessional rate of duty at the rate of 10% under the shelter of notification number so and to cover up such willful misstatement or suppression of material facts with the malafide intention of evading payment of GST on rupees so and so with the benefit of full availment of ITC on inputs of the aforesaid finished goods, they had made book adjustment by issuance of credit note dated so and so claiming a sales return after nearly 1.5 years of purported transaction. Well, I leave it to your lordship with regard to my lord this 73 and 74. But section 65.
That is the main point.
No, second point is very important. Circular. But there is a specific circular which is appearing at pages 94 and 95. As to when sections of this circular of the department, this is 13 December 2023.
Yes.
As to when section 74 can be invoked. But at page 95. Page 95.
Page 95.
My lord, 3.2. In this regard, section 74(1) of the CGST reads as follows. My lord, 3.3. From the perusal of the wording of section 74, it is evident that section 74 can be invoked only in cases where there is a fraud or willful misstatement or suppression of facts to evade tax on the part of the said taxpayer. Section 74(1) cannot be invoked merely on account of non-payment of GST without specific element of fraud or willful misstatement or suppression of facts to evade tax. Therefore, only in cases where the investigation indicates that there is material evidence of fraud or willful misstatement or suppression of fact to evade tax on the part of the taxpayer, provisions of section 74 may be invoked for issuance of show cause notice, and such evidence should also be made a part of such show cause notice. Such evidence has also to be made a part of such show cause notice. This is binding upon the department, my lord, I believe. My lord, now with regard to my lord, your lordship has already seen, my lord, the different years are there in the show cause notice, my lord. I have shown your lordship DRC 01.
Yes, yes.
Different years. Now, my lord, I'll just, because there are judgment with regard to fraud and everything, but with regard to clubbing, because your lordship has seen that, it has just separately. this is a single bench judgment of Madras High Court. The Honorable Single Judgment of Madras High Court, my lord, he has, my lord, the Honorable Judge, my lord, with deepest of respect, has thoroughly gone with regard to all these issues. My lord, first page, if your lordship kindly sees paragraph 2.1, the learned counsel for the petitioner would submit that in this case, the respondent issued a single show cause notice and thereafter passed a single assessment order for 6 years, financial years, with those so and so and so. The show cause notice was under challenge. So if your lordship now comes to paragraph 19, my lord, internal page 9, at the top the page numbers are given. Page 9, paragraph 19. Now,
Paragraph 19.
Paragraph 19. Has your lordship got that?
Yes.
Internal page 9. In view of the above, there is no doubt that in terms of GST law, any period for the purpose of issuance of show cause notice includes monthly tax period or yearly tax period, and the GST Act will not permit for issuance of show cause notice beyond such period. That is, no show cause notice can be issued for the period of more than one financial year. Therefore, as discussed above, a conjoint reading of the word tax period as defined in section 206 of the GST Act, along with the provisions of 73(1), 2, 3, 4, 10, 74, 1, 2, 3, 4 of GST Act makes it very clear that there is a specific bar in terms of section 73 or 74 for bunching of show cause notice. That is, no show cause notice can be issued for more than one financial year. While examining section 128, which deals with the power to waive penalty or fee or both, it is clear that the government may introduce any scheme by way of notification to waive in part or in full or any penalty. In such case, if a show cause notice was issued prior to the date of such notification by clubbing more than one financial year, the petitioners will be forced to pay tax amount for all the financial years included in the said notice for availing the aforesaid scheme introduced by the central. Hence, it will create a great hardship to the petitioners. A similar hardship will be faced by a petitioner when they intend to file application for compounding the offence under section 138. And it was concluded, my lord, at paragraph 28 at page 12. To put in a nutshell, the court passed the following orders. The GST Act permits only for issuance of show cause notice based on the tax period. Therefore, if the annual return is filed, the entire year would be considered as tax period, and accordingly, the show cause notice shall be issued based on the said annual returns. If show cause notice issued,
clubbing according to this is not
no, 4. If your lordship kindly says Roman 4, no show cause notice can be clubbed and issued for more than one financial year, since the same is impermissible in law.
There is a contra judgment of Delhi High Court I was shown in some matter.
I would like to see that. I'd love to see that, in fact, my lord.
There is one
from
Delhi
Mr.
High
Banerjee. Well, I just brought it, I think.
First, kindly come to the explanation. Explanation of
Mr. Siddiqui is done.
Not.
Yes.
Explanation to 65.
Explanation to 65. Yes.
Two important factors are there. For the purpose of this subsection, the expression commencement of audit shall mean the date on which the reports and other documents called for by the tax authorities are made available by the registered person or the actual institution of audit at the place of business, whichever is made. Therefore, in consonance with the explanation to subsection 4 to 65, Lordship may kindly turn to page 18.
Page 18.
And this is, as per my instruction, this is the date, that is 18/10/2024 is the date by which the audit under section 65 has commenced. Page 18, under the letter dated 17/10, we have gone to their office for conducting audits from 18/10/2024.
17th of October 2024.
In the middle page, Lordship will be conducting audit
On and from.
18/10/2024 is the effective date as per this explanation for the purpose of constituting or construing the date for which the audit has commenced as per subsection 4 to section 65.
Yes.
Second issue is with regard to the clubbing of so-called policies. So that over here, I'll be relying on that is public card readers. Kindly come, this is the Supreme Court by which the order was defeated, it was withdrawn. Kindly come to paragraph 53 and 54 at page 31. Of the Delhi High Court judgment. The court has
Yes.
paragraph that page 46, they have remanded or they were given liberty to the petitioner to approach before the appellate authority by exhausting the remedies as per the ACI. It was challenged to the court. After arguing the matter for a considerable time, the learned and counsel appears for the petitioner says that he does not want to press the petition, dismissed as not pressed. Second issue is regard to the same issue has been again considered by the Gujarat High Court. That said that the alternative remedy has to be exhausted, and the same question with regard to
Clubbing.
clubbing is also the issue before the Gujarat High Court.
Yes.
Next, with regard to the section 74 and alternative remedy, so it is a very complex one. Show cause notice, whether it is of the Madhya Pradesh High Court. I think so.
Show cause notice, it's settled that it has to be without jurisdiction.
It is always said, but something we got it.
No, this one, this Delhi High Court is a detailed judgment.
Okay.
Show cause.
Yes, there also the allegation was ingredients are not there. So that way it helps.
Again, the Delhi High Court also in another case, that is clubbing.
Relying on the earlier judgment.
Yes. in present judgment is with regard to the Delhi High Court.
The Ambika judgment has been relied on for this again.
Yes. Next issue is with regard to that is the Ambika credit. Second issue is with regard to various the show cause notice whereby they have been alleging that section 74 has not been invoked properly. Well, I'm just noting down the pages for the lordship.
Yes.
Kindly note pages 58,
58.
58, 60, 61, 62, 60, 61, 64, 65, 67, 68, 69, and 86.
86.
Well, these are the pages where the provisions of section 74 in relation to the activities of the petitioner has been mentioned below the factual matrix. In what way there has been fraudulent transfers? Well, your lordship will kindly for once come to page 57. I'll just for your lordship convenience shooting to some 2-3 lines of every
Page 57.
Page 57.
Yes.
Towards the end, towards the middle end, they have failed.
They have failed to provide.
They have failed to provide documentary evidence in respect of the movement of the goods from their registered place of business either directly to the port or to
Yes.
Now, over in page 58, before the words, the taxpayer is liable to pay, kindly see the appointment which has been made. Hence, it is apparent that the goods in question were sold in domestic market under the cover of aforesaid invoices of concessional rate of duty with the maligned intention to evade payment of GST. In page 59, the words towards the middle. Therefore, it appears to be established beyond doubt that the goods in question sold by so invoices have not been exported outside India, and hence they fail to comply with the provisions of and as such, as regards there are violated. In view of the above, the second paragraph in page 59, domestic supplies in the guise of concessional rate of duty and to cover up such willful misstatement of suppression of material tax with the maligned intention of evading payment of GST at the rate of 12. These are the primary allegations. Page 60 section 74 has been quoted in the third line. In the paragraph 2.4, from the last 3 lines, failure to provide the relevant information with regard to the bills of entry for import and return of the goods. In page 61, the department alleges that there is a violation of section 34(2), and they also say that it is a disguise of part-potent export invoices, and the section 74 has also been invoked. In page 62, also similar first 3 lines. The allegation is that receipts of different suppliers were found to be without having any goods received, labels, which are the testimony of of shortage. Thus, there is violation, and section 74 has also been invoked. Page 63, towards the middle, hence it appears that the excess sales over our actual sales as per debtors in trial bank is nothing but made for passing of ITC to raising invoices to different buyers without supplying of goods.
Page 74.
63.
Page 63. Which
The line which is starting from only, hence it appears.
Hence it appears. Yes.
These are the primary allegations. He has to substantiate by way of the written documents, which if he has done so properly and without any malice, he will ignore it. Is the primary allegation?
And what about the circular? The circular which showed that evidence is also required to be given along with the show cause notice.
Yes, but already it is forming a part of the enclosure. If it is forming a part of the enclosure, now it is a quasi identification quasi judicial proceedings. Now if any documentations or whatever audit report has been provided, it has been issued by the jurisdictional commissioner. Now it is a prima facie allegation and prima facie which has been found. Now to corroborate whether it is actual or not, he has to substantiate with those documents. Now it is not a case that he has been what to say found guilty unheard. It is a prima facie, and whether there is any substance in my show cause notice at this prima facie state, if your lordship, whether there is ingredient, prima facie ingredient of section 74 or not, and whether the wordings are there or not, to my understanding or submission, there are pleadings in paragraph 7, in page 77, 84, and 86. To that effect, by which we can come to a conclusion that the prima facie allegations which have been made against the petitioner is for invoking of section 74 and also the various subparagraphs which has been held against him. Well, like it is a prima facie one, we can always object to the same and take appropriate remedy. In my respectful submission, the prima facie allegations which have been made in the various pages that malafide intention to evade payment of tax, fraud and misrepresentation for evasion of tax under guise, no documentation provided, invoices issued without supply of goods, non-payment of interest, reversal of ITC. Lordship will kindly see the heading which was the explanation which under section 74 which signifies the what is suppression shall mean non-declaration of tax or information which a taxable person is required to declare in the return statement report or any other document furnished under this act or the rules made thereunder or failure to furnish any information on being asked for in writing by the proper office. So these are the prima facie allegations for invocation of section 74. If he is found that he has been honest taxpayer and all the allegations are without any basis, it is not a defense. So these are my
During the course of my submission, I submitted section 75 London Junior wanted I submitted. I was not pressing very hard upon section 74's ingredient sets. But my lord, some things are very vital, my lord. First of all, my learned friend said that the date of initiation of the audit proceeding should be counted from page 18, that is from 17th of October 2024 and not 2nd of May 2024. Now, this is astonishing, my lord, coming from the revenue. If your lordship kindly sees 2nd of May 2024, the language of that particular notice, whereas it has been decided to undertake audit of your books of account and records for the financial year 2022-23 in accordance with the provision of section 65, I propose to conduct the said audit at my office at your place of business. It started, and immediately thereafter, my lord, at next page, at page 16, I submitted the documents with reference to that particular. I submitted the requisite document. My lord, this is the email. My lord, this is, I believe, was on 5th of June 2024. So 2nd of May, they gave me that notice under section 65. And 5th of June, my lord, I submitted the documents. And in course of audit proceeding on 17th of October, they wanted to visit my place of business. They issued me further notice.
But then also then Mr. Siddiqui, if 5th June then becomes the date of commencement.
My lord?
Then 5th June will become the date of commencement.
Even 5th June, if it becomes, my lord.
Then if you receive it on 9th May, it is within.
No, my lord, that I'll show that also. Well, that is what has happened. But if your lordship kindly comes to that audit report, that is what your lordship was asking me.
Yes.
That Mr. Siddiqui, there is one more date.
Yes.
For the audit report, page 43. The audit report is of dated 2nd of January 2025.
Yes.
They say that the audit report was over by 2nd of January 2025, subject to correction.
Yes.
So then they ought to have been communicated to me within a month. That is what section 65(6) says. 9th of May 2025, it was communicated to me.
Just
my
a
lord,
minute, Mr. Banerjee, the language of section 65, the explanation with dates on which the records and other documents called for by the tax authorities are made available. Now, 5th June 2024, why will this not be the date on which it is made available?
Over here, Lordship is called upon to examine with regard to the commencement of the audit proceeding.
Yes.
Well, the law prescribes a two-way formula, a formula by which the statute prescribes what should be the exact date for commencement of audit.
Yes.
Well, here there are two instances or which has been given. It should not be constant to the end or mandatory. Well, over here it means the date on which the records and other documents called for by the tax authorities are made available to the registered person. Because all the documents and other factors, because audit is a complex.
Oh no, whichever is later.
Whichever is later.
So then Mr. Siddiqui, kindly come to the next limb.
Right.
The actual institution of audit at the place of business.
At the place of
business. Place of business is then 18th of October.
No, my lord, your lordship may kindly the place of business they visited. I have not supplied them any. Then the audit has never been completed.
No, Mr. Banerjee, this section takes into consideration two aspects, and it says whichever is later.
Commencement of audit, my lord.
Yes.
Explanation says for the
Commencement of
purpose
audit.
of this section, commencement of audit shall mean the date on which the records and other documents called for by the tax authorities are made available by the registered person or the actual institution of the audit at the place of business, whichever is later.
Whichever is later. Now
Whichever
the
is
later date. Later date. Now in a case where both are applicable, you will have to take the later date. Now here the later date then comes to 18th of October 2024 because this happens at the place of business. If it is only one.
We will, my lord, subject to correction, we will not only look into that place of business or supply of documents, my lord, shall mean the date on which the records and other documents called for by the tax authorities are made available by the registered person.
Yes, thereafter it doesn't stop.
Or the actual institution.
Whichever is later.
Of audit at the place. My lord,
whichever is, so it contemplates both. It contemplates
my lord,
the
subject to correction. Both, my lord, subject to correction, my lord. It means on the date when the records and other documents are made available.
Yes.
My lord, because it says this expression commencement of audit shall mean the date on which the records and other documents, on which the record and other documents called for by the tax authorities are made available by the registered person. But I made it available. That is 5th June 2024. Or the actual institution of audit at the place of business. My lord, does it imply, my lord, I put this question to myself, that actual institution of audit at the place of business means the date on which I made the records available to at my place of business, or the date on which they come to my place of business?
No, the date on which they start audit at the place of business. That is what the
that is what I am on.
The simple reading of the that is
but
simple
even my lord,
because see, Mr. Siddiqui, there can be a situation where the authorities are satisfied by the records that you have supplied. They are not required to visit your place of business anymore. They take stock of the documents which you produce before them. They consider it. They reach a conclusion. They say that yes, audit can be done on the basis of these documents. The second limb of the explanation will not be invoked.
Right.
Now, in a case where both the limbs have been invoked, you have to give the entirety of the section or entirety of the provision a meaning.
Right.
So this whichever is later has to creep in. Otherwise, both the limbs having been invoked and keeping is whichever is later out of the
even my lord, if I concede to that fact that they have, my lord, in fact come to my place of business on 17th of October 2024. So that will be the date of institution of commencement of the audit proceeding, as he is saying, as per the explanation, my lord. In that event also, my lord, the audit, my lord, the final audit was completed on January 2025. 2nd of January 2025, communicated to me on 9th of May 2025.
That by itself will not annul the proceeding if the ultimate time limit is followed, because from 18th of October 2024, they will still have that window of 10 months. Mr. Banerjee, can you throw some light on this? What is this 2nd January 2025, the middle portion of?
Well, to that another I cannot give much insight with regard to that clarification.
My lord, in fact, my lord, I did not find, my lord, subject to question, Mr. Banerjee is armed with the records as to what was there was any satisfaction on the part of the commissioner to extend that particular, my lord.
That may or may not be there,
But there has to be.
communicated.
But,
They are on the
it has
communication.
to be on the file, my lord.
That is there. That is there. That
Without-
the appellate
without-
authority will also.
Without the satisfaction of the commissioner, my lord, it cannot be done.
That the appellate authority can also take
But,
into
my lord,
consideration.
these judgment which was relied upon, my lord, in regard to clubbing of so-called notices.
Yes.
My lord, this is one. My lord, there is no merger. In fact, when this SLP was withdrawn.
No,
There is
that's
no
not
merger.
that. There are 2 High Court judgments. We'll go by that.
Both Delhi High Courts, I believe.
No, one you cited Madras.
No, no, my lord, I am not, my lord.
So there are
trying to distinguish the judgment.
The dichotomy is in between 2 High Courts.
My lord, I don't think there is any dichotomy, my lord. It's subject to correction, my lord. Again.
No, but Delhi High Court says that Section 74 language does not say that it cannot be clubbed. That is what it has said. If you see the division bench which he handed up, Mr. Banerjee, this Ambika Traders, the thick one.
Thick one, my lord.
Is kindly see paragraph 54.
54.
Yes.
But that is what I was, my lord.
Kindly see the last line of paragraph 54, the underlined portion. The language of the provision that itself does not prevent issuance of SCN or order for multiple years in the consolidated. It does not say.
But lord, there has not been much deliberation about that particular issue. In that case, if you also kindly read paragraph 54 with me, lord, the present case appears to be one such case where a substantial amount of ITC is alleged to have.
No, before that.
But we did the second decision, the coordinate bench of this court has clarified the position in law that a consolidated show cause notice for multiple days permissible under the purview of section 74, and hence the argument cannot be brought for detaining a writ petition.
So this is a general ratio. Then the next paragraph which follows and which has been underlined is in the facts of the case. Then again it has been qualified by the last 3 lines again in a general by way of a general ratio.
But again, my lord, in this case, what I find, my lord, that there has been a show cause notice only on the ground of availment of wrongful availment of input tax credit. If your lordship kindly sees paragraph 54, kindly bears with me. The present case appears to be one such case where a substantial amount of ITC is alleged to have been availed, utilized, running into more than rupees 83 crores. The petitioner is alleged to be one of the main entities person involved in the said activity. The transactions are between the year 2017 to 2021. A consolidated notice is therefore not merely permissible, but in fact required in such a case in order to establish the illegal modality adopted by such business entities. But there is a chain. There is a chain in that case.
Mr. Siddiqui, if the law does not permit it, let us have it viewed in this way. If the law does not permit something, then whatever may be the facts, I will not be able to invoke it in a particular manner.
Right.
If the law eschews completely, if that is avoided by law says it's not permitted, or the language of the law is such that I cannot I cannot interpret it in a way as if it permits me, then in that case I will not be able to invoke that provision and issue notices in a consolidated manner for several years. It is only if the law permits that I can do it, whatever may be the facts, even if the facts are the goriest.
Right.
Then also law has to permit me to do that. So it is not that because of these facts section 74 could be invoked. Section 74 SCN notices in respect of several years could be clubbed, and in other cases it will not be clubbed. That is not the law. Law has to be one. Law has to be one. Clubbing is permissible or not. If it is permissible, it will be permissible in all cases.
Then, my lord, we have to go through. Then, my lord, we have to go through the entire judgment, because the law which I have read in the Madras High Court judgment, my lord, in fact, the intent of the legislature has rightly been interpreted by the Madras High Court. The legislature has used the word tax period, has used the word financial period. If your lordship now kindly comes to section 73 or section 74.
Yes.
My lord, now if your lordship kindly comes to section 73 or 74.
Section 74. Yes.
But because here we are dealing with section 74.
Yes, yes.
The 74(1) is the show cause notice, my lord.
Huh.
Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement of suppression of fact to evade tax, he shall serve notice on the person chargeable with tax which has not been so paid or which has been so short paid, or to whom the refund has erroneously been made, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with interest payable thereon under section 50 and a penalty equivalent to the tax specified. The proper officer shall issue the notice under subsection 1 at least 6 months prior to the time limit specified in subsection 10 for issuance of order. But this issuance of order is with regard to one financial year, because each financial year there are different dates. Time limit which is specified under subsection 10, well, it has to be, because your lordship is coming across many matters now, my lord, I think, with regard to extension of time 168A, my lord. So there has a fixed limit of time even for section 74. So issuance of order, this is for a one financial year, there will be one date. For another financial year, there will be another date. So, my lord, if it is, my lord, read, my lord, in harmonious construction, all these provisions are read. This is for one financial year. Now, my lordship kindly seeks the next subsection, where a notice has been issued for any period under subsection 1, the proper officer may serve a statement containing the details of tax not paid or short paid or honestly refunded, or input tax rate wrongly availed or utilized such periods other than those covered under subsection 1 on the person chargeable with tax. The service of statement of subsection 3 shall be deemed to be service of notice under subsection 1, subject to the ground relied. The person chargeable with tax may, before service of notice of subsection 1, pay the amount of tax with interest payable under section 5 and a penalty equivalent to of such tax on the basis of his own sum and the tax asserted by subsection, inform the proper officer in writing of such. Such shall not serve any notice in respect to tax not paid, where the purpose of the opinion that the amount paid under subsection falls short of the amount actually payable, he shall proceed to issue the notice as per for in subsection 1 in respect of such amount, where any person charged under pays the said amount along with interest or penalty equivalent to 25 such tax within 30 days of issuing all proceedings in respect of said notice shall be deemed to be concluded. Now, my lord, I am supposed to, my lord, before issuance of show cause notice,
yes,
the law prescribes that there will be a pre-show cause notice, which is under section 73 subsection 5. Now, this pre-show cause notice is for the purpose of, my lord, giving me opportunity that these are the amount which you are supposed to pay, or else we will proceed with the show cause notice. Now, my lord, if I want to compound that, I want to pay that amount. Now, my lord, if different years are clubbed together, I will not be able to, my lord, at least this year, for this particular year, I accept that I have committed a fault. For that year, I do not accept that I have committed a fault. Now, my lord, if the show cause notices are clubbed together, then, my lord, it will create a huge.
But the show cause notices will have the breakups. The show cause notice will.
But
have
I
the
cannot pay, because the payment which I have voluntarily supposed to pay, my lord, is with regard to one show cause notice. I cannot pay by breaking it up. I would have to come before your lordship then, my lord, seeking that your lordship kindly, at least with regard to this amount, kindly allow me, my lord, to pay the amount. But with regard to other amounts, my lord, no authority will allow me to pay.
Why will that not happen?
Because the law which prescribes under section 73(5) that I have to, if your lordship kindly sees section 74 subsection 5, the person chargeable with tax may, before service of notice under subsection way, pay the amount of tax along with interest payable under subsection 50 and a penalty equivalent to 15% of such tax. There are, my lord, several years. This total penalty, how much I am supposed to pay, how I can back, the authorities will not allow me to bifurcate that.
So that will have to be done.
That is why the clubbing of show cause notice, that is what I am on. I was drawing an analogy. That is why, my lord, the show cause notice cannot be clubbed. On the basis of his own ascertainment of such tax, or the tax as ascertainment by the proper officer, inform the officer in writing of such payment.
Very good.
My lord, section 75(2), in fact, 74(2) will become OSHOs, my lord, if your lordship kindly sees. For different tax period, my lord, this has to be different dates. My lord, there may be cases where it will be time barred.
That they cannot do.
They
Time
cannot
barred
do.
they
They cannot do. But what I am on, my lord, your lordship was looking at that judgment of the Delhi High Court, the thick one, Ambika, and thereafter, my lord, my learned friend relied upon the other judgment, Sri Shyam Polymers, which took into consideration the Ambika's judgment. Lordship got that, my lord, Sri Shyam Traders. He was relying upon paragraph 6. Therefore, it is clear from the above decision that the consolidation of show cause notice for multiple years has been allowed in cases where ITC has been fraudulently availed, which is the primary allegation against the petitioner in the present case. In that case also, there is a primary allegation that he has fraudulently availed the ITC. Lordship got that, my lord, paragraph 6, my lord, the thin one, my lord. He has relied upon Syntax 2025 34 Syntax 184 Delhi. Here also the case of ITC. But if lordship kindly, the first page your lordship is rightly looking at.
Yes.
First page your lordship is rightly looking at, because this is the case of wrongful availment of ITC. Paragraph 6 at the next page. It is clear from the above decision that a consolidation of show cause notice for multiple years has been allowed in cases where ITC has been fraudulently availed, which is the primary allegation as the petition in the present case as well. In view of primary condition being settled, the above decision considers the fact that the impugn order is appealable. So, hereafter adjudication order they had made. So, my lord, ITC was the only ingredient available in both the cases before the Delhi High Court, subject to correction. If your lordship now again comes back to Ambika, paragraph 5, I'm sorry, my lord, to trouble your lordship again and again.
Yes.
Paragraph 5, internal page 2 of that judgment. A show cause notice
yes.
A show cause notice was issued to the petitioner on so and so date, along with form DRC-01 by the DGGI for the financial year so and so. We did the said show cause notice. A demand of rupees was raised against the petitioner on the ground of alleged fraudulent availment and wrongful passing of the ITC. This was the entire case of wrongful availment of ITC. Now, if your lordship looks at my show cause notice, why this will create a trouble if your lordship kindly comes to the elaborate show cause notice in the writ petition.
Yes.
Well, at page 77, quantification done by them after the conclusion of the investigation. Page 77.
Page 77.
Well, quantification and conclusion of investigation. Has your lordship got that, my lord?
Yes.
3.1 is the year-wise breakup of the availed and utilized ineligible ITC for the financial year 2019-2024 related to ITC availed of supplies, but the registration of the supplies were cancelled ab initio. This is, my lord, ITC. I have wrongfully availed and utilized the ITC. The next one, the amount of tax short or not paid and the ITC wrongly availed for the financial year 2023 as discussed above is also mentioned below. Short paid. Then, my lord, and here also the interesting feature is, if your lordship kindly looks at 2.2, the chart, that at the bottom, my lord, at page 77, at page 77 bottom, 2.2 IGST 0, 2.3 IGST 0. Then the next page 2.4, there is some IGST component given there. So this is with regard to ITC tax short paid and ITC wrongly availed. Now, if your lordship kindly comes to the next page 3.3, grand total of the taxes not paid by the taxpayer year-wise as obtained after aggregating the taxes at point number 3.2 above, and also the ITC availed irregularly on the supplies from the cancelled suppliers. So both these components are now clubbed together. Taxes not paid and wrongful availment of ITC. Then, my lord, for different years. Then, my lord, again, interest 3.4 is interest. 3.5 is penalty. This is not simplicity of the case of wrongful availment of ITC as was there before the Delhi High Court. With deepest of respect, my lord. And my lord, section 73 and section 74 does not contemplate, my lord, issuance of a singular show cause notice for different financial years with regard to, my lord, different ingredients. In the case before the Delhi High Court, my lord, in both the cases, my lord, it was there that the same individual for years together had been wrongfully availing ITC from fake suppliers. So there were paper transaction only, there were no suppliers. So the chain had to be established. My case is short payment of tax, non-payment of tax, wrongful availment of ITC, delayed payment of interest, penalty, everything clubbed together. Where is your printout? Well, there is a Bombay High Court judgment I have told by my learned friend, but where is the printout? Ambika Traders was considered by the Honorable Bombay High Court. It's a soft copy which is being shown by my learned friend.
What is the name?
This is Milrock Messrs. MILROC, Milrock Good Earth Developers versus Union of India. And this is a recent judgment of 9th October 2025. Paragraph.
Mr. Banerjee would require to.
Well, I'll just take 2 minutes. Well, today we are very free, my lord. The entire high premises is free. I'll just take 2 minutes. I'll just read the relevant paragraph. You know? Paragraph 23 of that, my lord. Sorry, my lord. Yes, just begin the chapter. This Asha Desai has relied upon the decision of Delhi High Court in the case of Ambika Traders, where the issue felt that when the issue that felt for consideration was whether the order original passed by additional commissioner and the fact revealed that the entity of sole proprietorship of Mr. So resident under the VAT regime migrated to the GST regime and a search operation was carried out at the residential premises and various files records were resumed. A show cause notice came to be issued along with Form DRC 01 for 5 financial years, demanding a sum of this with regard to Asha, that Ambika. It is in this background that Delhi High Court appreciated the submission advanced in the light of the specific provision of section 74 subsection 9 in the backdrop of section 75. The Delhi High Court, my lord, it says was passed the judgment in view of section 74 subsection 9 read with section 75. It is in the wake of wholesale fraud which attracted the attention and was the focus point of the decision. The bench took into consideration the definition of the term tax period as defined in section 106 and when it interpreted terms for any period and for such period in section 74. But I submitted the same thing, my lord, the Honorable Bombay High Court. The fact involved before the Delhi High Court being distinct and revolving around the wrongfully claimed ITC which was prescribed for the subsequent bench is quite distinct from the facts which are before us. In any case, SLP was withdrawn by Ambika Traders before the Apex Court and the said decision will not apply to the facts in the present case. Well, the same thing. But that is what I was submitting. Last there cannot be clubbing of the show cause notices.
Very well.
I'm grateful.
89 and 90 is the synopsis of our show cause notice. The ingredients are there.
and 90. And what is your reply to this? That he says that he will not be able to avail the benefit of section 50.
It can always be segregated within the adjudicating authority. These are both issues. The mind of the adjudicating authority that some
No, he says that if the pre-show cause notice is also given in that fashion, then in that case he may not be able to.
In fact, my lord, in this case they have not issued. In that case, they have not issued any issue.
First, my lord, is the remedy of a show cause notice. Well, final adjudication order is not before your lordship. Because in majority of the cases, adjudication has been allowed. Now, over here, the adjudication is not before your lordship. What is the outcome of that? We also do not.
Very well. I'll keep it one more day. I'll just go through it.
I think, my lord, Leonard June ought to have taken that point because they have not issued DRC 01A because I have been there for so many years. My lord, at least pre-show cause notice ought to have been issued after the audit.
Very
Directly they went into the show cause notice.
लिखे नहीं heard Mr. Siddiqui, Leonard senior advocate appearing for the petitioner, and time নয় আর্জেন্ট হিসেবে যেরকম আসে আর্জেন্ট মোশনে ঢুকিয়ে নেক্সট original side.
May I be permitted to mention item number 363, my lord, assigned hearing matter, my lord. Yes. This long time it is pending, my lord. May it be taken up on any day, my lord. In
We'll
the
take up hearing matters.
next week, my lord. Kindly, my lord. My lord.
Your Lordship, I want to mention an original side matter upon notice. Your Lordship, Mr. Roy is there. Your Lordship, here the petitioner's right to livelihood is affected. He was an employee in a custom broker firm. He has resigned. But the firm is supposed to inform the department. They are not doing that. Department has also issued a letter to the firm, but they are not responding to that also. And he is not getting any salary. And unless his name is deleted from the portal, he cannot take employment elsewhere, Your Lordship. This may be given priority. It is item number 22, Your Lordship. Priority any day next.
ওই ওপরে তুলে দেবেন
Grateful.
Because we have not received the brief as of yet.
Your Lordship, I am carrying an extra copy. I can give it to them.
she's giving a copy to you. Take instructions.
My lord, Wednesday?
Let us see. We'll try to keep it on Wednesday.
Grateful.
Keep a watch on the list. চলুন কল করুন
Item number 1.
My Lordship. My Lordship, Mr. Anjan Bhattacharya, representing the petitioner, is unwell today.
Should I appear for the petitioner in item number 1?
Opposition. Let us not extend. Item number 2.
One, I am for the High Court administration.
So item number 2, I am for the petitioner.
GA1 in what? Please wait, let us hear the petitioner first. Mr. Mojumdar, you are in 1 and 2 both?
No, I mean item number 2. I am for item petitioner in item number 2, my lord. Mr. Devnath Ghosh, senior advocate, is leading me in this matter, but due to some personal difficulties.
1 and 2 are they involve similar issues. Connected and told same recruitment.
Same recruitment process.
But the point in item number 1 is whether or not there can be a shifting
of an unreserved category candidate whose name appears in the merit list for the purpose of filling up the post of assistant registrar, court recording in the original side, to the available vacancy of unreserved category candidate in the exempted category. That's the point involved in item number 1.
And in 2 also?
These are almost similar, I think. In item number 2, the writ petitioner, there is filed the petition, he says that he had offered his candidature as a unreserved category. He ought to have been treated in the reserved category as an exempted category candidate, and he complains that by the alleged slide, who did not offer his candidature as an exempted category candidate, was treated as an exempted category candidate, and that is how the writ petitioner accordingly here was tried.
Mr. Banerjee is leading you in both the matters?
No, 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 no. I'm in item 1.
In second, he is not there. Second, you are there.
Yes, and Mr. Kaur is there. Mr. Kaur is not available.
Second, so what to do about 2? 2, should we adjourn and proceed with 1, or what do we do? Because
My lord, both matters, my lord, may be taken up on a later date, my lord. Recording a formal order.
Only not if it comments to your lordship, I don't stand in the way of not being represented by their counsel. That's not a problem.
So we can proceed with 1. 1 will not be concluded today. I don't think it will be, or it will be, I don't know. If it can be, it can be. But if it is concluded, then 2 will have to wait till it is heard.
Subsequent, there is another writ petition to which an appeal was taken up by the High Court as well by as an outcome of that appeal, the candidate appearing in application J1, he has been allowed to join the service.
Your application GA1 is in which matter, 1 or 2? So wait, we are at 1 first. Let 1 proceed. Then we shall see 2. 2 এর brief টা দেননি তো আমাকে? 1 এর দিয়েছে. You have filed your opposition in 1 or 2? 2 টা একটু ফেরত দিবেন. Very well, very well.
One, my lord, we have filed a report in the form of an affidavit affirmed on 11th of June 2025. My learned senior friend has used an exception.
Yes, Mr. Molin.
Now, my lord, this involves an employment notice issued on 2021, 17 September 2021, for the purpose of preparation of a panel to fill up 14 vacancies in the post of assistant registrar. Please come to page 25.
Page 25, yes.
Applications are invited from Indian citizens possessing knowledge in the vernacular of the state for preparation of a panel for filling up the 14 vacancies in the post of assistant registrar, court recording, high court original site. The appointment will initially be made on purely temporary basis but are likely to be made permanent. Classification of vacancies, please see unreserved is 1. And as regards unreserved in the exempted category, it's 4. But I am concerned with 1 and 2. That's the serial numbers 1 and 2 in the categories of vacancies. Therefore, I need not trouble your lordship on any other point. Now,
yes.
Please come to page 28, which
28
lays down the mode of selection. Admission to the examination will be deemed provisional, subject to verification and determination of the candidate's eligibility and suitability in all respect. If at any stage of the process a candidate is found to be ineligible for admission to the test in terms of the notice, his candidature shall be cancelled without making any reference to him, without assigning any reason. Candidates whose applications will be found in order in all respects shall be required to undergo the following selection tests. The candidate shall be required to undergo a test in shorthand at the speed of 160 words per minute for 3 minutes. Full marks of the test is 480. After completion of the above mentioned time, the candidates will have 50 minutes time for correction of outlines and transcription of the dictated passage in their handwriting. Candidates securing 40% marks in phase 1 test will be called for appearing in phase 2 test. In this phase, the candidates shall be required to undergo a test in shorthand at the speed of 160 words per minute for 5 minutes. Full marks of the test is so and so. That a candidate will be given a further time of 10 minutes immediately after the completion of the dictation for verification of the outlines. After completion of the above mentioned time, the candidates have to transcribe the dictation passage at so and so. A panel of provisionally selected candidates shall be prepared and the same shall stand lapsed on expiry of 1 year from the date of its notification or on filling up of the notified vacancies, whichever is earlier. In case of any dispute, the decision of the Honorable Chief Justice or Honorable Chief Justice Acting High Court at Calcutta shall be the final. Then I need not detain your lordship on any other aspect. Admittedly, the panel was prepared in 2024, which your lordships will be pleased to find at page 34. In furtherance of the employment notification dated 17 September 21 and in continuation of the merit-wise result, with a notification dated 14th August 2024 regarding filling up of 14 vacancies under various categories for the post of Assistant Registrar, Court Recording, High Court Original Site, Calcutta, the following lists are published for general information. List A. The list A1 to A9 shows the names of candidates selected for appointment to the post of Assistant Registrar, Court Recording, High Court Original Site as per the extant rules. Category-wise lists of selected candidates for their appointment to the post of Assistant Registrar, Court Recording, High Court as per extant rules. Please recollect the unreserved category declared vacancy was 1. So, roll number 355 secures the first position in the merit list against the unreserved category. Then list 2, category unreserved EC declared vacancy 4.
No one found suitable.
No one found suitable. Now, my clients rank between 2 to 5. 2, 3, 4 and 5. Now, they seek that this unreserved category vacancy declared with the horizontal reservation of EC, which could not be filled up because of non-availability of suitable candidates, should also be filled up by them. That's the case made out in the writ petition. Now, in support of this, my clients have relied upon certain past practice, a Government of West Bengal notification, and certain other processes which had been undertaken by this administration as well as by the district judgeship for the purpose of this shifting from one category to other category. It's really not another category as such. It's a horizontal reservation at the most. But the vertical reservation is caste-based reservation. The horizontal reservation comes not within that category.
Unreserved exempted category, what is it exempted for?
Let's say dying in harness, land losers. That comes under, by way of example, comes under the exempted category. But not the vertical. There are two types of reservation, as now the Honorable Supreme Court has pronounced. One is the vertical, which is caste-based reservation. General, OBC, SC, ST, like that. Then what comes the horizontal reservation within that category, say PWD, or dying in harness category, or somebody who has lost his land because of some project being undertaken. But I found this procession last time I visited the circuit bench. There was a land losers procession for the purpose of establishment or construction of the building. They had carried out a procession. Now, just to demonstrate that this has been the practice followed, if your lordship will kindly have a look at page paragraphs 7, 8, 9 and 10.
Yes.
Page 6. Petitioners submit that the petitioners have collected various documents starting from the employment notification dated 17 June 2019, being number 1, for the post of stenographer grade 3 to fill up such vacancy of 3 unreserved exempted category. The district judge Howrah had appointed 3 candidates from general category candidature when no suitable candidate had been found. Not the panel is annexed. Next paragraph, the petitioners submit that the petitioners have also collected the notification dated 19th October 2020, issued by the Registrar High Court Appellate Site, Calcutta, from which, from the final merit list of unreserved candidates to fill up 31 vacant posts, only 5 candidates were found eligible in the exempted category segment. Thereafter, to fill up the balance 25 vacant posts, candidates starting from serial number 6 to 31 have been accommodated from the general category list. The petitioner submit that previously on 30th April 2013 an employment notification had been issued by the Registrar General High Court Calcutta, by which the posts of lower division assistants were to be filled up by placing properly qualified candidates from the list of selected category of candidates. But on 5th June 2015, while preparing the panel, the respondent had placed general candidates serially from the panel to fill up the vacant posts of lower division assistant in the absence of the reserved candidates, just to run the administration for the interest of justice. That paragraphs 10 and 10 is also important. The petitioner submit that in a similar case, with a notification number so and so dated 7th August 2020 to fill up the vacant posts of stenographer grade C on the appellate side of the High Court at Calcutta, the High Court administration has followed the same norm to place general category candidates to fill up the declared vacancy of 10 exempted category candidates, as there was no such candidate available in the exempted category group. This shows that the High Court administration, along with the Office of the District Judge Howrah, had followed similar proposition by which the conversion of vacant posts from general category to exempted category to fill up the vacancies lying in the exempted category to meet up the needs of the administration. But in the present case, such procedure had not been followed at all. Therefore, the petitioners are aggrieved by the inaction on the part of the respondents should be allow the petitioners from getting such much awaited employment in spite of rank from serial numbers 2 to 5 in the merit list for the post of assistant registrar court recording. So, drawing inspiration from the past practice, apropos not the position as it stands today, which will stand fortified from the government of West Bengal notification also, that I shall demonstrate that I have a right to claim this shift. Now, please come to the, there is an exception filed to the report, I believe.
Yes, there is. Have it. Have it.
There is an exception. Now, please come to the notification issued by the government of West Bengal, that from time to time I straightway take your lordship to the latest one of 2019 at page 15 of that exception.
$15.
1-5.
It's only 13 pages.
Exception.
11 June 2025.
That is my report in the form of an affidavit. My learned friend is paying exception.
Affirmed on
Exception to it.
17th June 25. Finally.
Not yet filed.
But I just not a Anjan kothay nahi ashen. But for the time being, if your lordship will kindly take my copy, not pages 15 and 16.
Yes.
Now, please turn over. That's the subject matter of that notification at page 15. Please turn over. It's probably marked.
Yes.
Almost at the middle portion of that page. Probably clause 5.
Yes. Since none was found suitable,
this shifting was directed to be made or made allowable. Now, in so far as reserved category candidates are concerned, there is a reserved category in the sense of caste-based reservation. There is a provision constitutionally made for the purpose of carrying forward of vacancies. Suppose I don't get a suitable candidate to fill up a post of SC in this recruitment process. I fill it up through a general category candidate, but this reserved category post would be carried forward till the next exercise is carried out or completed. So, in the next exercise, if there is one reserved category vacancy, it will be counted as 2, because there was none found suitable in the earlier process. Now, this is how, just to demonstrate that the administration has also done this, I have referred to those pleadings. Now, please come to only one document at page 30. No, I'm sorry. Please come to page 44. Yes, the document begins at page 37, 17 June 2019. This is for a different post, of course.
Yes.
But Lordship may straightway come to page 44.
Yes.
Now, this was the mode of or qualification for the post of stenographer. Now please turn over to page 49.
Yes.
3, 4, 5, 6, and 7. This refers to the 17 June 2019 employment notification. Your Lordship will be pleased to find that each one of them was appearing under the category of UR.
Yes.
UR. Now, each of the statements pleaded in paragraph 7 to 10. Now, please come to, for another process, please come to page 55. And I was referring to serial numbers 5 to 31 being filled up by another one, by other category. Please come to 55.
Yes.
Down below, there is a caption unreserved exempted category vacancy 31.
Yes.
Then another instance is 64.
64.
My lord.
64.
And merit panel is prepared. Please see, these are all general category candidates. Then turn over the page to 65. Serial number 21 is Shayantan Banerjee and 34 is Shayan Chatterjee. These general category candidates had been shifted.
Yes.
Now, the 2020 for the 2020 process, your lordships may refer to page 70 at page 74.
Page 74. Yes.
Unreserved exempted category declared vacancy 10. Now 1, 2, 3, and 4, they are all unreserved.
One, 2, 4, 6, 7, and 8.
Yes. Now, the moot question is whether this shifting in the subclassified category is permissible or not. That's the moot question. Now, At,
and
at,
whether you can claim that as a matter of right.
But
Although it shows that somewhat consistency is there in the practice that is being followed, but whether that practice can be given the exalted status of a right.
yes. Now, not for that note, I am referring to that government notification as well. Not which is, of course, not the each High Court has to frame its own rules. Not in the absence of rules, there has to be some certain guidelines. Now, not what do I have a right to occupy the post? That's the question, and I claim it as a matter of conversion. What can stand in the way is an existence of law which debars such conversion. Now, the category, the vertical reservation is like this. General, so general is not a reservation. OBC, SC, ST. Now, under the PWD Act, which is now that 2016 Act, there is certain reservation in based on the nature of disability. There has to be a percentage of vacancies reserved for particular categories. In the general, 1% for hearing impaired, something like that. Now, this exempted category falls within the category of unreserved. Now, 4 were found to be vacant, which were notified for the purpose of filling up. None found suitable. So, the broad classification is UR 5. 5 seats in the UR category are vacant, out of which the subclassification is 4 belongs to the exempted category. Loosely, it can be contended as a horizontal reservation.
Yes.
But we are probably out of
Yes.
time.
But maybe continue next week.
Next Friday, not subject to that.
But may it retain its position
Yes,
at the
so that
top.
the continuity is
It will,
not lost.
because Fridays are for specially assigned
Yes.
cases. Only thing is time may change.
Yes,
Instead
no,
of
not an
early,
issue.
Maybe earlier.
But some Fridays, the specially assigned matters, they go down.
No, that was happening because of the vacation approach.
Yes, yes.
Because hearing nobody would do.
Very well.
Correspondence is taken on record.